You may be seated.
Good morning. The time is 10 a.m. We're going to call to order the legislative style hearing of the Public Service Commission, the District of Columbia, in formal case number 1176 in the matter of the application of the Potomac Electric Power Company for authority to implement a multi-year rate plan for electric distribution service in the District of Columbia. I'm Emil C. Thompson, Chairman of the DC Public Service Commission. I am joined by Commissioner Richard Beverly and Commissioner Ted Trabue. Today is July 30th, 2024, and we are convening this legislative style hearing. This legislative style hearing is being live streamed on the Commission's website. Please turn off all cell phones so that there are no distractions. I would now like each party to identify themselves and their representative who will be speaking today. First, we'll start with PEPCO, the Potomac Electric Power Company, then the Office of the People's Counsel for the District of Columbia, and then the interveners. I understand that some parties present will not be speaking, but please introduce yourselves for the record.
Good morning, Chairman, Commissioners. My name is Kim Curry, and I represent PEPCO, and I will be speaking today. And with me is Dennis Jamino, Assistant General Counsel with PEPCO.
Good morning, Anka Schneier, Assistant People's Counsel with the Office of People's Counsel. And I'm also joined by Sandra Madavu-Fry, the People's Counsel.
Good morning, Your Honor. I'm Fran G. Francis, appearing on behalf of the Apartment and Office Building Association, referred to as AOBA. I will be speaking today for AOBA.
Good morning, Commissioners. My name is Brian Caldwell. I'm Senior Assistant Attorney General with the Office of the Attorney General, representing the District of Columbia government. I will be speaking today.
Good morning, Michael Engelman, on behalf of the District of Columbia Water and Sewer Authority. We will not be speaking today.
Good morning, Christy Singleton, representing General Services Administration, and we also will not be speaking today.
By way of background, on April 13th, 2023, PEPCO submitted an application for approval to increase existing distribution service rates and charges for electric service in the District of Columbia by $190.7 million through the implementation of a multi-year rate plan for calendar years 2024 through 2026, which is labeled as the Climate Ready Pathway. PEPCO requests authority to earn overall rates of return of 7.77%, 7.78%, and 7.79% for the MRP years of 2024, 2025, 2026, including a return on common equity of 10.5%. If approved as requested, the typical monthly residential distribution bill would increase by $6.05 in the first year, an additional $6 the second year, and an additional $5.96 the third year, for a total increase of $18.01 over the 3 years. For an average customer using 614 kilowatt hours a month, this represents an increase of 16.4% over the 3 years compared to the current total bill. PEPCO states that the benefits of the proposed MRP for the years 2024 through 2026 are that it is forward-looking, provides transparency into the company's planned investments, allows customers to better predict rate increases that are spread over future years, and helps to ensure alignment between the district's energy vision, the commission's mission and goals, and the company before investments are made. The commission directed PEPCO to file supplemental testimony and exhibits along with supporting schedules to support a traditional one-year rate case for the test period calendar year 2023. Both proposals are before the commission. Interveners oppose PEPCO's MRP proposal and traditional one-year rate cases for the test period calendar year 2023 for various reasons. In accordance with the directives provided in a notice of legislative style hearing issued on June 13, 2024, and order number 22013, issued on June 28, 2024, the commission has asked the parties to present oral arguments before the commissioners regarding issues that the parties believe are fundamental to the commission's decisions in this proceeding. The commission determined that each party would have 30 minutes for their presentations, proceeding first with PEPCO and OPC. The other intervener parties will proceed in alphabetical order. PEPCO can reserve time in its 30-minute presentation to respond to other parties. Commissioners may ask questions during the hearing. If possible, please avoid acronyms, which may be difficult for the stenographer and others to comprehend. Please state what the word is without using an acronym. You should all know commonly used acronyms like DOEE, MRP, OPC, and PSC, but there may be others that are not as well known. Like I said, a stenographer is transcribing today's hearing. Please speak slowly so the stenographer can capture your presentation for the transcript. If a speaker wishes to discuss confidential information, the party needs to advise the commission when they propose doing so. I want to ensure that only those who have signed the appropriate agreement regarding confidential information can remain in the hearing room during the discussion. While confidential information is being discussed, we will disconnect our live stream and turn off cameras until the discussion is completed. We will then continue with the live stream. Before we begin, do any of the parties have anything they wish to raise or ask? Yes, Ms. Curry.
Yes, Chairman. Kim Curry, representing PEPCO. We have one initial procedural matter, and it involves AOBA's limited brief. Attached to their brief was an affidavit of one of their witnesses, Bruce Oliver. We think that was improper for them to attach that affidavit. The commission has said that this is not an evidentiary hearing, that witnesses will are not to appear. So we would ask that that affidavit be stricken.
We'll take that matter under advisement. Thank you.
Your Honor, is this the right time for me to respond to that?
Yes.
PEPCO, in response to commission order. Thank you. PEPCO, in response to the commission order, attached two affidavits with this supplemental filing that they filed on July 5th. We had asked to put on testimony. We had asked for PEPCO to put on testimony. The commission declined that request and instead allowed us to submit data requests. We had no other way to respond to PEPCO substantively other than an affidavit that we attached to our limited brief in response to the affidavit, which is akin to testimony that PEPCO filed on its July 5th filing. So I believe it's proper and it should not be stricken.
Thank you for that. Again, we'll take this matter under advisement. Anything else? Okay. If nothing further, we will go ahead and begin with PEPCO. Please head toward the podium, restate your name again, and spell your last name for the stenographer. And how much time do you wish to reserve for?
1 minute. Your Honor, we're having a little bit of trouble hearing you over here. Could you speak a little bit louder, please?
Okay. I'll pull a little bit closer. Is that better? Better. Okay.
Good morning, Chairman. Commissioners, Kim Curry, representing PEPCO. My last name is spelled C-U-R-R-Y. I would like to reserve 10 minutes of my oral argument for rebuttal. Commission should approve PEPCO's MYP for two reasons. First, it meets the objectives announced by the commission in two orders. First, the order on alternative forms of regulation, known by the acronym AFOR, as well as the order on PEPCO's last rate case in FC 1156. FC is formal case 1156. Those orders state what the benefits are to an MYP. The commission has already stated and held that there are benefits to the MYP to customers, the commission, stakeholders, shareholders, and the utility. That's precedent, and that should not be disturbed here. But although it is precedent, that does not mean we should not always look for ways to continually improve the MYP process. And indeed, that's what PEPCO intends to continue to do. And in fact, in this MYP, we have announced a few enhancements that I'll talk about later in my oral argument. The second reason the commission should approve this MYP is that the company is experiencing a revenue deficiency. Rate relief is needed, and this MYP will help provide that relief. The rate adjustment that's proposed in our MYP provides for recovery of capital investments and O&M spend that helps the company provide safe, reliable, and resilient service to customers. The bill stabilization adjustment, or BSA, as I will call it, should also be approved and continued because it remains an important tool for the company to support energy efficiency programs. And recovery of the BSA deferral balance, and that represents the amounts that the company is not able to recover due to the 10% cap and the BSA, should also be approved for recovery because to disallow those amounts to be recovered would implicate the rules against retroactive rate making, and I'll talk about that as well. So we engaged in a very thoughtful and deliberate process in developing our MYP, while at the same time being mindful of the impact to limited income customers. So as a result, we proposed in this filing to expand enrollment in the Residential Aid Discount, or RAD program, as well as the Arrearage Management Program, or AMP. The customers on RAD will not experience a rate increase as a result of this MYP, and I'll also talk about that as well. One item of note as I close out my summary is this oral argument does not afford me enough time to cover all the myriad of issues that we raised in our MYP. So as a result, anything I don't cover today, I'm reserving the right to cover in post-hearing briefs. Okay, so let's take a detailed look at why the commission should approve the MYP. I mentioned there were two orders. The first is the AFOR order, and that's order number 20273. This order requires that the utility provide detailed information to meet the needs of customers, stakeholders, and the commission, and the utility as well. The principles in the AFOR order are clear, and that framework provides very thoughtful direction and framework for the filing of an MYP. Now, OPC alleges in their brief that the company has failed to meet the commission requirements. We disagree. The direct testimony of company witness O'Donnell, specifically page 43, table 3, on that page, in that table, we list all the requirements of an AFOR and how the company has addressed it in the MYP, and whose testimony we address each one of those. OPC, AOBA, and the District of Columbia government, they all argue in their briefs that the company has not shown that the MYP that we filed in formal case 1156 produced benefits to ratepayers. Again, we disagree with that. The company filed supplemental direct testimony on August 31st that provides information on the qualitative and quantitative benefits as a result of the MYP. Right now, I'd like to focus on the order in our last rate case, FC1156. PEPCO's MYP embodies the benefits for stakeholders and customers envisioned in that order. Specifically, paragraph 473 of that commission's order, the commission identifies the following benefits of an MYP. One, providing ratepayers with transparency in assessing utility spending and investment decisions. So parties gain a greater understanding of the company's investments before they are made. Second, predictable rate increases spread out over years. This helps us achieve gradualism. Customers know in rate 1, the rate and the amounts they're going to be paying in every year of the MYP. With the historic test year, customers do not know the timing nor the amount of a rate increase. Third, administrative efficiency due to reduced filing of rate cases. The commission has said that that's a costly undertaking. We avoid that with a 3-year MYP. And then finally, reduction in regulatory lag. Now, one additional impact that was not mentioned in the commission's order, but one not to be overlooked, is the impact on diverse suppliers. Diverse suppliers can grow their businesses the longer the MYP is. That's because they know what the utilities' needs are 3 years in advance. They're able to staff up to be able to meet our needs. We also included with our direct testimony an economic impact report that showed the benefits to, the DC market. And so outside the four corners of our MYP, we are heavily engaged with local businesses such as through the Empowerment Academy, and we detailed all of that in the testimony of company witness McClure. So not only has the company relied on the commission's guidelines in these two orders, we have also actively enhanced the MYP process by incorporating lessons learned from our prior MYP in FC 1156. A couple of examples. One, we rely on the company's long-range planning process, or LRP process, to develop our revenue requirements. And that's the process where we budget looking 5 years out. Now, this is ideal. It's more ideal than the escalator that was approved in the last case, because we're able to match the revenue requirements to actual planned investments that we intend to make. Another enhancement is improvements in the billing determinants process. We developed a sensitivity calculator that allows parties to run different sensitivities to challenge our assumptions supporting our sales forecast. Another enhancement is we instituted additional controls in the billing determinants process to validate our billing determinants forecasts. So that's just a couple of examples of the continuous improvement that I talked about earlier, but we remain open to feedback. Incorporating learnings from prior MYPs continues to be our goal. However, the quest for continuous improvement does not mean we have to halt the implementation of MYPs until the process is perfect. Just by way of example, in December of 2023, the Maryland Public Service Commission approved an MYP of another utility, Baltimore Gas and Electric Company, while at the same time in that same order convening a statewide lessons learned process. So this shows that you can implement and approve an MYP, but at the same time conducting a lessons learned process in parallel. So it's supportive of commission policy, but also district policies as well, to help the district realize its climate goals. The direct testimony of company witness O'Donnell at page 6 lists what those DC climate goals are, including transportation electrification and GHG emissions reductions. Investments from the company will be vital in supporting the increased electrification envisioned by the district. And PEPCO does all of this while mitigating the impacts to limited income customers. The MYP contains proposals to increase the number of customers eligible for the residential aid discount, which provides a credit for nearly all of the distribution portion of eligible customers' bills. Again, these customers will not see an increase under the MYP. The MYP also includes a proposal to increase enrollment in the arrearage management program, which credits customers' bills who pay their bills in a timely fashion. So that's how the company's MYP comports with district policies and commission policies. So the commission should also approve the MYP because the elements making up the MYP are appropriate and reasonable. So let's look at a few of the elements making up our MYP. Let's start with the Bill Stabilization Adjustment, or BSA. That's the revenue decoupling mechanism that removed the link between customer consumption and utility distribution revenues to eliminate the disincentive for the company to promote energy efficiency. This remains a necessary component of the rate-making process. So why should the BSA continue? For a few reasons. One, the BSA continues to serve its original purpose to encourage customers to encourage the company to support programs that encourage customers to reduce their energy use and support the adoption of energy efficiency. But not only energy efficiency. renewables, solar, net energy metering, distributed energy resources, mechanisms that help customers manage and reduce their usage. This is all also supported through the implementation of the BSA. Indeed, Atrium, the Commission's independent auditor of the BSA mechanism, found that the structure of the BSA is well designed to meet the goals of supporting energy efficiency. A second reason to keep it. The BSA continues to provide important bill protections for customers, normalizing the impact of extreme weather on customer bills and ensuring that any utility over recoveries are returned to customers. Another reason is that the DC Commission has acknowledged the benefits of the BSA to the financial health of the utility. Now, there is strong reason to continue the BSA in the context of an MYP, the assumption being that the argument is that the company can forecast energy reductions into their sales forecast, and therefore the BSA is not necessary. It is still necessary for a few reasons. One, the DC and Maryland Commission have approved a BSA in the context of an MYP. The Maryland Commission most recently did this in December for Baltimore Gas and Electric Company. Another reason to keep the BSA in the context of an MYP is that it protects customers against fluctuations in their bills due to increased energy usage caused by extreme cold or extreme heat. Another reason to keep it within the context of an MYP is that the company would have an incentive to only encourage reductions down to the amount in the forecast and nothing more. So continuing the BSA removes that incentive to do that. And the final reason to keep it within the context of the MYP is that the company would not be incentivized to promote new energy reducing programs if those programs are incremental to the reductions assumed in the forecast. So a few reasons, those are just a few reasons why the BSA should continue in the context of the MYP. Now, the company has proposed enhancements to the BSA mechanism, again, in the interest of continuous improvement. And this is, these enhancements were developed at looking at best practices in other jurisdictions and gaining feedback from stakeholders. A couple of examples. One enhancement is displaying the BSA surcharge on a separate line item on customers' bills to enhance transparency. And two, transitioning from a monthly reconciliation to an annual one to reduce rate volatility by flattening out over and under recoveries between months. So the BSA should be retained. Now I'd like to turn to discussion of the BSA deferral balance. It's justifiable to allow recovery of the deferral balance. There are two primary sources of that deferral balance. One is the FC1150 normalization adjustment. That created a $27 million revenue under recovery resulting from a settlement in FC1150. This under recovery did not result from a PEPCO error. Rather, it was an agreement of the parties to design rates for a particular rate class, that was GTLV, based on forecasted counts that proved not to materialize. That $27 million deferral balance has declined to $3.4 million as of December 2023. And now standing here, almost through, completely through 7 months out of 2024, that balance has reduced even more. So this should not be a basis for denial. The outstanding balance is very small. And again, that was due to a settlement agreed to by PEPCO, AOBA, and OPC. There's equally no reason to disallow any part of the BSA deferral balance related to the company's billing determinant error. This was an issue in which the company inadvertently overstated its billing determinants used in its rate design for FC1150, and that resulted in a $15 million under recovery of distribution revenue. This issue was corrected in the following rate case in FC1156. This deferral has been reconciled through the BSA mechanism, and as of December 2023, only $1.1 million of that $15 million error remained in the deferral balance. And by now, again, sitting here in July, that amount has reduced even more. Both of those foregoing deferrals have been substantially collected, and that collection should not be disturbed because it is a commission-approved tariff. It was recovered through a commission-approved tariff, and it would be contrary to precedent as it relates to retroactive rate making to eliminate a balance that has been rightfully accrued and substantially collected. Finally, before I move away from the topic of the BSA, the company agrees with AOBA's and OPC's proposal to recover the uncollected deferral balance of the GTLV rate class outside of the BSA, specifically through a reg asset. The parties proposed this mechanism, reasoning that the large part of the GTLV BSA deferral basis is related to the COVID-19 pandemic, and we are okay with recovering that through a reg asset. Now I'd like to turn to the company's capital investments. These expenditures support a safe, reliable, and resilient distribution system, and they should be approved. They are the product of a rigorous project authorization process in which the company identifies the benefits of the project, and that process is vetted all the way through senior leadership. Now, AOBA has challenged our authorization process, arguing that budgets change too much between the initial stage and the final project execution, but this refinement is due to the normal budgeting process. The company estimates the cost at the beginning of the project, and that cost estimate is further refined as the project proceeds. The company has articulated how this process works. So basically, we develop a cost estimate, and then we develop a range around that cost estimate. So 50% above or 50% below, that's the range of the cost estimate. And as the project proceeds through the scoping stage and engineering stage, that bandwidth is tightened more. So the refinement of the budget is not out of the ordinary. That's very normal. Also, in the interest of continuing improvement, the company has made enhancements to the information in its construction report to provide greater transparency into how projects are allocated between Maryland and DC. Specifically, in previous reports, we would only provide information related to DC distribution. In the enhanced version of the report, we include additional details for projects that are allocated between Maryland and DC. And if those projects are greater than 1 million. So we've included or expanded the types of projects that are available for scrutiny by the parties in the context of the rate case. O&M. The development of our O&M costs are equally rigorous as to our capital process. The business develops the budget by looking at historic spend, regulatory requirements, operational goals, and then that budget is revisited throughout the year. We manage our O&M costs below the rate of inflation, which demonstrates reasonableness. And finally, on the O&M topic, the shared services costs, which was a subject in testimony, those are the costs that are allocated from our parent company to PEPCO. They're transparent, and there's an accounting process that supports those allocations, and that's filed as part of the CAM. ROE, an increase in the company's ROE is fully warranted. Calls from AOBA for a reduction in the ROE from its current level must be rejected, as it is unreasonable to believe that PEPCO's ROE could have decreased from the level approved in FC1156 when all other capital costs have increased significantly, and as well as in a rising inflationary environment. Now, my final point involves the RRR report. The OPC has argued on brief to dismiss the MYP due to the 2023 ROR report. That report, when we updated it, showed the company at a 9.155 ROE, which has been under what was approved in our last rate case. Thank you.
Thank you, Ms. Curry. I'll begin where you started. I want to go back to the lessons learned that you talked about a little bit from 1156. In order number 21886, Commission directed PEPCO to submit supplemental direct testimony addressing in qualitative and quantitative terms the benefits of, problems identified, and lessons learned from the MYP. I know you cited the testimony from August 31st that witness O'Donnell provided. I failed to see in there any quantitative analysis. Is there something I'm missing?
There is a specific question on the quantitative and qualitative analysis. So yes,
question
there
is
is. There is a Q&A on that. And if you give me a moment, I can grab it and
Okay,
direct your attention to it.
please do.
It is on page 3, Q3. And the question is, can PEPCO provide more specific qualitative and quantitative benefits of the FC 1156 MYP?
Yes, so I see that answer there, but maybe I didn't ask. These are statements, right? And I guess one of my questions is, where is the data that supports that? I look at specifically the DRs that AOBA asked the company, please provide work papers, data, analysis, assumptions, and studies that PEPCO relies upon to quantify each of the benefits achieved by the modified MYP. And PEPCO says, well, there are no such work papers. No work papers, no data, no analysis, assumptions. And so it's hard for me when I'm looking at the benefits without some actual numbers. There's assertions, but where is the data to support that?
As it mentioned in our DR, we do not have that data, but what we do have is discussing how the company's MYP meets the commission's policy goals. And that's what we have in our lessons learned testimony. And that's what we presented as the support for the qualitative and quantitative data. So just to give a few examples of that is that we do have increased levels of transparency as a result of our case. We've provided the rate predictability that was anticipated in the commission's orders. We reduce the frequency of litigation as a result of the MYP by not having to come back every 3 years. And as we mentioned in our testimony, we were able to redeploy those resources to developing our Climate Solutions Plan, or CSP. So those are the benefits that we've identified, looking at the commission's orders and how we've complied with that order. But to answer your question, as the data request states, we do not have that supporting work papers and data.
Has there been an analysis of cost with respect to litigation of a multi-year rate case? I believe the last one was 18 months. This one is going on about 16, 17 months compared to the litigation that's that a traditional rate case, the cost of a traditional rate case?
If you're referring to a cost, so like for employees and those type of companies' costs, no, there has not. But, as the example that I gave mentioned, if we're not coming in every 3 years, then we are not using those resources every year towards a historic test year. And we're able to, use employees to do other things. So that's where the benefit is being able to redeploy those employees' time and resources. But to your question, we do not have an analysis of the cost side by side for doing a historic test year and an MYP.
I'll turn to my fellow commissioners for questions.
My question is more basic. Why did PEPCO file an MRP? I call them MRP, MYP. Why did PEPCO file an MRP without waiting for the commission to evaluate the pilot?
Well, in the commission's order, I believe it was 21886, the commission asked for testimony, and they specifically referred to it as lessons learned testimony. So The way to view that order is that the commission's intent was to consider lessons learned in the context of this case. The commission developed the procedural schedule to consider the MYP alongside the lessons learned testimony that the commission asked us to provide. And as I mentioned earlier, that this is a process that was done in Maryland where an MYP was approved, but at the same time, the commission convened a lessons learned statewide lessons learned analysis. So the two can coexist, and we believe it can coexist. And we also believe that's consistent with the commission's orders.
If I think that the pilot should have had other elements in it that the MYP lacks, what should I do with the MYP? Reject it? You say they can be done in parallel. I'm not understanding how that happens, but if I think that your application should have something that it lacks because you did a self-evaluation, that's fine, but that's not a commission evaluation. So if the commission evaluates it and it thinks there's something that these programs should have that yours doesn't, then you think the MYP should be rejected? Or with your parallel view of analysis, what should I do with it?
What you could do is put it in your order. So in your order approving the MYP, if you approve the MYP, if there's certain changes you'd like to see, put that in the order. You can say, here is an element that we would like you to add to the MYP. So I don't think you are foreclosed from making those suggestions.
What do you mean add to it? Retroactively or going forward?
It would be going forward. It would be incorporated in the MYP. So in the
Already
order
filed,
looking
so
3 years.
Just trying to understand, you've already filed it. So what would I do with it now? I would tell you to add it to it now. And does that restart the process?
Not to restart the process. If there's something, depending on what it is that you would want to add, the order is forward-looking.
I'll
So
give
if
you
there's something,
So suppose I say that I think an MYP should have PIMS in it and yours doesn't.
well, for that specific example, I would say PIMS is, as we mentioned in our testimony, that is under consideration by the working group. And that process hasn't completed yet. So after that process completes, then we would have to figure out a way to move those into, if you want to see it in this rate case, maybe it's something that gets postponed to the next MYP. But using PIMS as an example, that's a process that's actively being considered by the commission, and we could not have included it. But if that does
Wait,
appear or
You
that
could have
gets
waited,
resolved,
right?
I'm sorry,
You said the process hasn't concluded on the PIMS, but you didn't wait for it to conclude.
I'm sorry.
You didn't wait for the PIMS process to conclude, right?
We did not wait for the PIMS process to conclude before issuing the MYP, but that was not an improper action from the company. The commission
But that
in
still
its
doesn't
order
answer the
said
question.
that we can file an MYP prior to January, the commission or the company is not able to file an MYP prior to January 1st, 2023. So we did have the ability to file an MYP after January 1st, 2023 per the commission's order. So it wasn't an improper action for us to file our MYP.
Right, so in answer to my question with regard to PIMS, I should wait until the working group concludes on that. So while I'm waiting for the working group to conclude, should your application be held in abeyance?
I do not think it has to be.
How would it include it if it's, I don't understand how your application, if I thought it should include PIMS, would ever include PIMS other than in some future application. But what do I do with the current?
If it cannot be included in the existing MYP, then it's something that can be added to the next MYP.
All right, let me ask you, and I'm not going to keep going along that line. I understand your answer. With regard to your investments, it seems like Pepco has large investments with little expectation of customer growth and kilowatt growth to match it. So can you explain that a little bit more for me?
Low expectation.
Not low, low expectation. I guess what I'm trying to say here is that your investments in the system appear to be larger than your expectations of customer growth. Do you agree with that, or you think it matches?
I wouldn't necessarily agree with that for this reason. The MYP is also intended to accomplish or meet district climate goals. That means looking at reliability, that means preparing our system for increased electrification. That might not always be necessarily tied to a particular customer, but it's more trying to meet larger district goals.
Do you have a plan of some sort that shows, because I'm not, maybe you do, I'm just not seeing it, but do you have some kind of a plan of how whatever it is you're talking about doing with regard to the investments in your system match what the district is trying to reach climate-wise? So for me, I would need an integrated resource plan to sort of understand how this all fits together. This appears to be operating without any sort of a plan that I can discern that shows how anything matches any particular goal. So as the chairman pointed out, there's not data to quantify what PEPCO's talking about in terms of benefits to ratepayers. I don't see how it's hinged into any kind of a plan that shows long range what you're trying to do, so I can measure your ability to achieve what you think you're trying to accomplish.
Where I would say that plan resides is in our annual consolidated report, or ACR. That does contain some level of strategy for future and planned investments. So that's one place that one could look to see kind of that, projection of what we intend to do. For specific district goals, attachment 4 to the Cantler rebuttal testimony does list a number of items within our MYP that are intended to meet the commission goals. And that includes fleet electrification, reduction in sulfur hexafluoride emissions from company equipment, building usage programs to reduce our GHG emissions. Those are just a few examples of very specific projects tied to a climate goal.
I'm gonna ask. Thank you.
Thank you, Mr. Chairman. Thank you, Commissioner Beverly. Ms. Curry, it's a pleasure to see you this morning. And for those of you in the audience, thank you for participating in this important hearing. Let me maybe follow up where my colleague left off in talking about your planning for future and planned investments. You stated a few minutes ago in response to Commissioner Beverly's question that these investments were to enhance reliability and to help the district meet its climate goals. Would you agree that the company is already in the top percentile of companies that are evaluated nationally in terms of reliability?
We do have good reliability, yes.
Would you also agree that in FC1167, it's the company's position that the grid as it currently stands can support the increased load that might potentially result from electrification?
I'm sorry, Commissioner Traby, could you repeat that?
Sure. Would you agree that in FC1167, it was the company's position that the grid as it currently stands can support increased load from electrification?
I would have to review FC 1167, but assuming that is true, let's assume it's true for the purpose of the.
Right. So let me understand further then, or better, why you need these funds that are being requested for these investments for additional reliability and to help the district hit its climate goals, when it seems like the distribution grid currently is in very good shape.
Currently, but one part of the MYP is looking forward. It's looking at what's going to be required for the increased electrification demands that are going to be put on our system as a result of climate initiatives for the district. So one can't just look backwards at our historical reliability. We want to maintain that reliability, as as more is expected out of our system. So I would say that looking backwards to the historic reliability is not the best measure. It's what can the system sustain going forward.
Can you comment on the load growth in the city over the last 3 years? Seen an upward trend, downward trend, flat?
I cannot, standing before you today, comment on that. If it's going upwards or downwards,
All right.
perhaps if you can cite something for me, that would be helpful.
All right, let me switch topics for a minute. Let's go back to the BSA. You spent a good bit of time in your opening testimony discussing this matter. In your testimony, you said that the BSA was initially created probably what, around 2009 or so, to help incentivize the company to support some of the initiatives that the city was launching in terms of energy efficiency programs.
That's correct.
So that, okay. I think you further said that the BSA was enhanced to help the company make sure that it was not harmed by, how did you put it? There are, I don't want to say the economic, well, but weather, weather normalization piece. And then the third piece, it seems that I'm wondering about is the economic downturn that has clearly impacted not only the city, but nationally. There are fewer people coming into work. Some buildings now completely vacant. Clearly, that's had an impact on revenues to the company. Is the BSA designed to also help the company offset some of those losses?
The BSA, and I'm going to say this from a lawyer standpoint, the billing determinants we developed by projecting sales forecasts. And to the extent we update our billing determinants, we would, update our sales forecasts. So it would be captured in there. And if I'm wrong, I'll come back in on my rebuttal time and let you know. So I believe it would be captured through that process of the update of the billing determinants.
Okay. What metrics does the company examine to determine what sort of impact the city's energy efficiency programs have had on your revenues?
I am not aware of any specific metrics, but that does not mean they do not exist. I can say that I'm not aware of any particular metrics.
Would it be possible at some point later on to, obviously, if that's one of the key factors in the BSA, you have to be looking at something to say that these are the impacts of the city's energy efficiency programs.
And specifically, you're looking for capturing load reductions, energy reductions.
Right.
Yes, I can find that out if we do something like that. The issue is we do not have our own energy efficiency programs. Those are where you would kind of do a lot of the metrics and looking into load reductions when you kind of own and operate and implement the program. Here, we would have to be capturing it from another entity, the DCSCU. So that's my only hesitation in saying whether or not we have metrics to measure that.
Okay. All right. Mr. Chairman, those conclude my questions. Thanks.
Thank you. I do have a few brief questions for you because you brought them up and I want to make sure I hit on them. You talked about some of how this climate ready pathway plan supports the district's climate goals. As you're aware, in 1169, the most recent Washington Gas rate case, Washington Gas proposed a number of climate programs to support the district's climate goals. In that case, we rejected those and said that the proper place for those programs to be approved were in formal case 1167. Do you feel that we should treat you guys differently?
So we do have pending programs in 1167. And so we are awaiting a decision on that. So we do have programs already in that docket.
Right.
Is your question to move these district goals to that?
Right.
Or should be considered there? I would say no. If you're looking at the AFOR order, I believe one of the goals is to look at or incorporate district goals into the MYP process. So I would say there is room to address those reduced electrification goals in this MYP. The second thing I would say is a lot of what needs to be done to support district goals is transportation electrification. That involves upgrades and investments in our distribution system. And that to me is rightfully a distribution cost and should remain in the MYP.
My second question is, we talked today about the BSA, and I hadn't really been prepared to go there, but since you spoke so extensively about it, the BSA, you gave 3 reasons why. You talked about EE, normalizing extreme weather events, and of course, financial health of the company. You also talked about the MYP, which part of the benefits of that is financial health of the company. And then part of the reason why there was a needed for an increased ROE is the financial health of the company. Where does the customer fit in with all of this? Everything seems to be the financial health of the company. Where does the customer see some reductions? I would note, I think Commissioner Traby was touching on this. The residential customer, their usage has declined by about 20% over the last 10 years, but yet the bill keeps going higher. How are they incentivized to use less energy when their bill continues to go up?
I'll answer that in a couple of ways. First, I will say that the commission and the AFOR order did indicate that the financial health of the utility is one of the things to consider. So there should be no shame in considering that as a component of our MYP. Secondly, customers benefit from a financial healthy utility. Why? Because we can borrow at more favorable rates and pass those savings on to customers. So it's important to have a financially healthy utility. Third thing I would say is we have, as I mentioned, expanded plans for our RAD program, residential aid discount, AMP, arrearage management program, to help bring more limited income customers under the umbrella of RAD. And that could help them completely avoid the rate increase because they're going to receive a credit on their distribution portion of the bill.
Seriously, last question now. Hypothetically, and I know I'm putting you on the spot, out of those 3 things that make the company financially healthy, which one is least important?
They're equally important.
If you had to pick one.
I do not think we have to choose. I really do not think we have to choose, nor do I think the AFOR order required that we choose between that. There is a balancing impact, right? It's not good for customers if your utility goes bankrupt. It is not good for customers if you do not have a financially healthy utility. So I don't think we should be put in the position of having to choose that, nor have I seen that in any of the commission's orders. I've always understood it as a balancing of those interests: customers, utilities, stakeholders.
No further questions. Well, at least for me, I'm sorry.
I'm fine, Mr. Chairman. Thank you.
Thank you for.
Maybe one last question. I'm sorry, Ms. Curry.
I knew quicker.
Did I hear you state that some of the balance that's in the BSA deferral balance, you would be okay with that being put into a regulatory asset?
That is correct, but that is a very specific part of it. It has to do with the GTLV rate class. That portion could go into a reg asset, and that was something that we agreed with. I believe it was both OPC.
Yeah, I think it was
and
AOBA's position that should happen. Okay, yeah, okay. But and you did. I just want to make sure I
That
heard
is
you.
correct.
Okay,
The GTLV portion, though.
Okay. Thank you.
I just had one question before I start. Is it my understanding that you'll wait for questions?
Sorry, can you please identify yourself
Sure,
for the record?
Ankush Nair, Assistant People's Counsel for the Office of People's Counsel.
And your last name, just one more time, I couldn't hear you.
Nair, Nayar. And I just had a question about the format. And you may have mentioned it at the beginning, but will I be afforded 30 minutes and then there will be questions at the end?
Correct.
Okay. May it please the committee.
Mr. Chairman, he might want to reserve some of that 30 minutes for rebuttal. Oh, he does? Okay. See, I'm new to this, sorry.
Good morning, Chairman Thompson, Commissioners. I already introduced myself, but I'll do it once more. Ankush Nair, Assistant People's Counsel. And I have to be honest, preparing for today has been a bit of a challenge. I'm not really sure what the weight of this legislative style hearing really is. I'm not sure it's been used, it's been coined a legislative style hearing. It's been coined an oral argument. I'm not 100% sure whether OPC will have an opportunity to litigate this case or appear before you at a later juncture, or whether the commission will decide this case dispositively or proceed to rule on the merits of the case. So there's a little bit of question marks surrounding why we're here. But what's clear is that this case concerns a petition by PEPCO for a rate increase. And equally, if not more importantly, it involves fundamental questions regarding the integrity of the process by which rate increases may be granted and how paradigm shifts in rate making are considered. And yet, when approaching these decisions, the central issue remains the same: whether PEPCO has met its burden of proof and whether there's a reliable record to support the rate request that the company has asked for, and whether the commission should grant it through an alternative form of rate making. The simple answer to whether the company has met its burden is no. And due to the lack of a reliable record in this case, there remain a number of unanswered questions surrounding the MRP pilot, the MYP, the traditional test year filing, and the implementation of any multi-year rate plan, as well as other considerations involving structure and the comparisons between the different applications. Therefore, the appropriate course of action in this proceeding is to dismiss the case or alternatively award summary judgment in favor of the joint movements. Now, OPC is not opposed to alternative forms of regulation per se, but for that form of regulation to work, the process has to be clear. In fact, the Commission's own words have been that the process needs to be deliberative. And that is not the case here. A denial does not mean no forever. It just means that this particular application doesn't meet muster. And I would argue that the worst thing that could happen if you are a fan or interested in alternative forms of rate regulation is to champion something before it's been thoroughly vetted and before the implementation of that plan is clear, because that's only going to create more confusion and that'll lead to bad results, which will more than anything else have a chilling effect on future approaches to alternative forms of rate making. And confusion has been part of this process right from the beginning. And I want to take a moment to look back last year at Order 21886. And I have a lot of thoughts, but I think the individual that perhaps summed up how I felt, how OPC felt, and really summed up the issues in a very powerful way was none other than Commissioner Beverly. And he noted that at the very beginning that PEPCO's multi-year rate petition presented two, and I use the quotes, too jumbled a process with too little time for meaningful review, while acknowledging multiple concerns that were raised by intervening parties. And Commissioner Beverly further opined that the party responsible for what would amount to a, quote, waste of resources was PEPCO for electing to file a multi-year rate plan prematurely prior to an evaluation of whether the preceding multi-year rate plan pilot was even beneficial. And Commissioner Beverly stated then that the commission should act on its own to dismiss the MYP proposal, even though no party had filed a motion to dismiss the matter at that time. OPC and other parties shared Commissioner Beverly's concern and have subsequently filed two motions to do just that. And 16 months later, the assessments, as well as the concerns shared by OPC and other parties have held true. If anything, the jumbled process is only more muddled. Added to the mix now is the question of whether ratepayers are entitled to a refund based on the company's 2023 financial returns, which remain subject to evaluation and have to be reconciled with an amended filing or errata that PEPCO filed only a few weeks ago. There were also supplemental filings that were subsequently filed, and we're still evaluating those filings. In fact, discovery responses were coming in this very morning. So OPC has made its position clear, and if this case is not determined by the two dispositive motions, that further proceedings must take place, specifically evidentiary hearings. We also highlighted that there's a lack of a real evidentiary record in this proceeding. And certainly there would need to be additional proceedings of some kind, even if there were not evidentiary proceedings. One thing I would say is that, and it was highlighted earlier today, that I think intervening parties should have an opportunity to submit additional testimony if we're going to continue to proceed forward with this case and decide it on its merits. But I want to really focus on the record and what a problem this would be for any commission or agency to base a decision off of. For starters, the projections in this case are inaccurate, and new evidence indicates that the old projections in both applications inflated the rate base and any revenue deficiency for calendar year 2023. Secondly, there's been no formal finding by the Commission regarding the prudency of investments made in calendar year 2023 in the actuals themselves, suggesting that even the more conservative numbers in the actuals themselves may actually be inflated. And like I mentioned earlier, we're still assessing the supplemental filings, and our witnesses have not had an opportunity to testify to those matters. Third, we have had an ineffective and unclear reconciliation process, which is carried over from formal case 1156. There has been no formal finding as to the prudency of those investments in the pilot and whether the investments were used and useful. And there are significant deviations from what was promised and approved in the MRP pilot versus what the company actually proceeded to invest in. As our second dispositive motion points out, the company neglected to spend close to $97 million on investments that were part of its multi-year rate plan. Moreover, PEPCO also incurred $155 million of capital costs for projects for which it had only budgeted $52.8 million. Now, the company has stated that no party requested a hearing following the submission of the final reconciliation in 1156, but only with additional time have the parties become aware of the level of deviation in spending between what was promised versus what was planned versus what actually occurred. And for the record, OPC did submit comments expressing concerns during the reconciliation process, as it was permitted to do so under orders 20755 and 21042. Yet we received no response at that time from the commission, and we even got pushback from the company. So the company likes to emphasize that there's a lot of transparency, and that looks good on paper. But when it comes to actual application, the process has not been transparent, and there continues to be problems that remain unresolved with the reconciliation filings. But the result, I think, perhaps has come to really, affect and hurt PEPCO, because the MYP contains projections that were based on investments that were made during the MRP pilot that deviated from what was planned and for which there's been no real examination as to the prudency of those investments. And even if we just look at the numbers at face value, and we stated this earlier, but the rate base was inflated in the MYP by $100 million, and the rate base was inflated in the traditional test year by over $300 million. When you look at the actuals. In the MYP also, there was a revenue deficiency that was inaccurate of $29 million, and the actuals suggest that at best there's a $2.2 million deficiency. And for the MYP, that's particularly problematic because, as you know, everything compounds off of that first year. So we're already starting with something that's incorrect, inaccurate, and then it builds from there every successive year. Now, this leads to a fourth issue. There will be no, at least on OPC's part, admission to stipulated testimony in this case. I know there's a deadline of August 21st, but we cannot stipulate to the exhibits and to the testimony that PEPCO's experts have testified to because we feel that it's based on data that is erroneous. And so that creates a lot of challenges. And that's one reason why we would feel that were you to proceed forward with this case, not dismiss it, not award summary judgment, you would have a very difficult time establishing a record from which you could base a decision without an evidentiary hearing, as was the case in 1169. I also want to take a moment to also look at some of the problems between the applications themselves. And you heard Pepco talk extensively about the BSA. I'm not going to get too into the weeds with the BSA, but what I can tell you is that for whatever reason, they decided that for their traditional test year, they want to put deferrals of the BSA into the rate base and earn a rate of return. And they didn't do that in the multi-year rate plan. There's no explanation for this. The only explanation they gave was, well, Atrium Economics provided a study and they thought it would be a good idea for our credit rating, but that's not the basis, or at least certainly not the sole basis as to why something should go into rate base. And it has nothing to do between the two distinguishing features of an MYP or a traditional test year. So again, you're starting off with something where there's inflated costs or an inflated rate base with additional expenditures in one and not in the other for that beginning year. Also, if you look at 2023, in both applications, there are the rate base is higher, $200 million more in one. And there's also adjustments, for example, in electric plant and service that are much higher in the traditional test year filing than in the bridge year for the 2023 year in the multi-year rate plan. So I think that also has really affected how we can examine these two applications. But OPC understands that really the heart of what Pepco is trying to achieve is trying to get a MYP approved. And I want to focus on that application briefly. The company has certainly not met its burden with respect to the MYP, and the application remains deficient. For starters, there are no performance incentive mechanisms that are in place in this multi-year rate plan proposal. And there is numerous orders, Order 20273, 18846, and Order 20755 that discuss how critical performance incentive mechanisms are to any multi-year rate plan. And the company's had months to come up with a proposal or offer something, and it has not. And it knew very well that there was a separate working group, and that working group was working on developing some PIMs. That working group seems to be at a standstill, and yet it proceeded to file an application knowing that this central component is not there. So I just don't know materially how you can approve an MYP without any kind of performance incentive mechanisms that would help control and rein in this particular plan. Additionally, while Pepco claims that this MYP would help the district achieve its climate goals, OPC has found that most of the investments, about 90%, are just business as usual. They're replacing like for like. They're not modernizing the grid. And when asked about whether any of these programs can be tied to specific district goals, in our discovery responses, the company said it could not correlate any of its investments to specific DC climate-related goals. That analysis had not been performed. And additionally, there remain a number of programs that are still under review in 1167. So for those reasons, the MYP and approving such a plan faces a lot of challenges. I also want to talk briefly about the simultaneous review. OPC has always objected to the simultaneous review of the MRP pilot with the MYP. But from what little ability we did have to perform a review, we found that the MRP pilot did not lead to any specific benefits that, and certainly not any benefits that would have not arisen had a traditional test year plan been in place. In fact, our witness, David Dismukes, explains that during the MRP pilot, there's evidence that affordability did not improve, that greenhouse gas emissions did not improve, and that there was a lack of efficiencies in operating and capital costs. The MYP proposes an unprecedented $186.5 million rate increase over 3 years, and the traditional test year case asks for $108.1 million. If the MYP is approved, it would mean ratepayers would pay an additional $452 million over the next 3 years, over and above what they're paying right now. And residential ratepayers and the residents in this district have to deal with real economic challenges and changing conditions as well. I believe Chairman Thompson's pointed to the fact that we see a lot of information and a lot of talk about the company and what's good for the company, but what's good for the consumer, what's good for the ratepayer. And I want to share just a couple of general thoughts about that. From 2000 until 2019, there's been a 78% increase in the bill for a resident. Over the last 20 years, food and housing has increased by 59% and 70% respectively. The District of Columbia has a great degree of income inequality among the highest in the nation. And what's worse is that in addition to trying to increase capital expenditures, the company seeks to put an additional burden on residential ratepayers to shoulder those costs. Denying this rate petition acknowledges that there are legal standards, however, that must be met before this happens. And it does not mean that Pepco cannot obtain a rate increase at some point. It simply acknowledges the obvious, that there's insufficient and unreliable evidence supporting their application right now. Accordingly, this case should be dismissed or denied dispositively. Thank you.
Thank you, Mr. Nair. That's it.
Yep, you said it correctly.
Okay. You do have more time if you want more time to speak, but you can be.
No, I think brevity is the soul of wit, so.
I like it. I like it. Okay. My first question is going back to a number of the filings that you guys made in your motions to dismiss. Repeatedly it was stated that there were no issues of material fact. Is that OPC's position, or was that? I'm trying to reconcile that with then the request for an evidentiary hearing. So there are no issues of fact, or there material issues of fact? I just
Sure.
explain that.
Yeah. And actually, if I do have some time, I may try to address some of the points raised by Pepco, but I'm going to first try to answer these questions as best I can. So as we point out, if the commission decides or determines that these motions should be denied, there's a summary judgment motion that's part of both of our dispositive motions. And so by denying that, that would be a sign that there are issues of material fact that are in play. It's difficult to assess. I know there's been some disagreement over what the commission believes is an issue of material fact, and might be policy considerations versus what we believe. But I think from our standpoint, the threshold questions, would warrant dismissing the case because they've not met their burden. But if we were to proceed forward, there's certain issues that could be up for discussion. For example, the ROE or the rate of depreciation.
Okay. Thank you for that. So, okay. And then with respect to the PIMS, you cited as one of the reasons as to why the absence of PIMS is a reason why this is materially deficient. You cited relevant orders 20755, 20273. Do they require an MRP to have PIMS, or does it say it should have PIMS?
I think that they say, I believe one order says shall, and I think another order says, should. I have to go back and check, but I believe that we stated in our initial motion that the language was quite strong, recommending that PIMS and there's a lot of language suggesting that PIMS are an essential part of any multi-year rate plan. In fact, we would argue that without the PIMS, it's not really a multi-year rate plan, it's just a multi-year rate.
Okay. And then you gave an interesting stat about the cost of increase of consumer bills. You talked about 78%. I'm just curious, is that for the distribution portion of the bill, or is that the entirety of the bill?
I think that may be the entirety of the bill, but I'd have to check.
Those are my initial questions for now.
With regard to a multi-year plan, what elements do you think a plan should contain? So you said would be one. Should it address things like hosting capacity, DER? I'm just trying to get an idea of some other things you think a plan should contain, or do you think that before you do a plan, there should be integrated resource planning? I'm just trying to get an idea what OPC's position is in a little more detail.
Yes, I mean, there should be an integrated plan. From personal experience, I think there has to be clarity as to the reconciliation about how that's going to work. And some way of allowing the parties to understand that, and this could be perhaps created through a PIM, that what the company promises to spend and what's approved, the company actually spends on, and that we have an ability to actually look at that in an earnest manner.
Was there any attempt, and I just don't remember this off the top of my head, but was there an attempt by the parties to decide what a multi-year plan should have in it in terms of reaching a consensus?
I would, when in 1156?
At any point, was there a meeting between the parties as to what, anywhere, in this case or any other one, as to what the elements of an MYP should be?
There were prior proceedings before. I don't think there was anything in this case, other than we did ask for a sequential review at the onset of the case when we were setting the procedural schedule, but no.
Right, I just wanted to make one comment before I turn it over to Commissioner Trabue, but with the motion for summary judgment, it's a two-pronged test, so I just want to make sure that we're clear. It's a two-pronged test, that you don't believe that there are issues of material fact and that you believe that you're entitled to judgment as a matter of law. If the motion is denied, that doesn't automatically throw back on the table that there are issues of fact, because it can be denied because you don't think, the commission doesn't think you're entitled to judge them as a matter of law. It doesn't create issues unless somebody had some issues. It's, to my knowledge, it doesn't work that way.
Well,
I've never seen it work that way. So I'm just trying to make that clear. I'm not following that line of reasoning. So if you think there are issues of fact, then you'll have to identify them.
I'll say one thing, there has to be a genuine issue of material fact. So it has to be material to the case.
But you'd have to identify them. They don't just pop back on the table because the motion is denied, unless it was denied because the commission says, we think there are genuine issues of material fact. We don't say that, and we say that we think that you're not entitled to judgment as a matter of law, then you miss the second part of a two-pronged test, but it doesn't create issues of fact unless somebody says that there are genuine issues of material fact, unless we said we thought there were genuine issues of material fact. We didn't say that.
Are there legal grounds to dismiss the motion for summary judgment?
I'm sorry?
I don't know if there are legal grounds to
I wasn't suggesting that your motion for summary judgment should be
dismiss, but
not considered. I think it was considered and it was denied, to my recollection, not because we thought there were genuine issues of material fact, but because didn't think the parties were entitled to judgment as a matter of law. So it just missed the second part of the test. Just because you deny the motion for summary judgment does not mean that there are genuine issues of material fact. They just pop into existence. It doesn't work that way, to my knowledge. That's all I wanted to clarify.
Sure.
I'm not trying to put you on the spot or have an argument, but I just wanted to make clear that's not my understanding of how this works.
I'll say make one point, which is that if a decision that the commission makes is going to be most likely deemed arbitrary and capricious if it doesn't address all the arguments that have been raised in and during the proceedings. And my understanding was, based off of how the commission ruled on this last, on both the dispositive motions, was we don't deny this right now. We're not considering the motion on the merits as a matter of policy. We're going to wait until after the legislative hearings.
And so I think that's exactly what happened. I think the commission denied the motion for summary judgment and said there was the issues that undergird the motion. For instance, an argument that there should be PIMs or something like that. You can still say that.
Mm-hmm.
You can say that at any point. And if you were to get judgment on that, it's not summary judgment, it's just judgment. that you think that there should be a ruling in your favor. I'm not trying to I'm not trying to
Understand.
belabor this point. I just wanted to put out there that I don't think the way you were articulating it is quite right, at least not based on my understanding of how this works. That doesn't mean that you can't argue argue the underlying elements that OPC wants to assert, that there should be PIMs or whatever it is that you think there should be. You still can do that, and that's what that order preserved.
Yes, and I think I'll just echo off of that, and that, you know, and this is what I spent a considerable amount of time talking about, is just the record in the case is quite problematic.
Can I get a better understanding of what else it is that, I know that you think there should be an additional proceeding, but an additional proceeding to establish what? So if you think that, and I understand your position, you think PEPCO's submission is deficient, do you want an additional proceeding to further establish the deficiency, or are you trying to establish something else?
No, if it's deficient, we'll take the dismissal and we'll be on our way. No, if we're going to look at the merits of the case, look at what the ROEs, what capital expenditures were actually worthwhile, what weren't, then we would want an ability to submit testimony and actually litigate the substantive issues of the case in terms of, and we mentioned this in our brief, the pre-hearing brief, the structure and the amount of a potential rate increase. You know, a lot of our arguments are based off of statements or lack thereof from the company itself. For example, there was no economic analysis done. There was no real quantitative economic analysis done. Even the idea of lessons learned, you know, sort of, I think, undermine one of the principles of an A4, which is, alternative forms of regulation, which is that we have to look at what are the benefits to the consumers. If you're looking at lessons learned from the perspective of a company, you're not getting the perspective of the consumers or the ratepayers from that perspective. So there's a lot of issues that, you know, that basically PEPCO has not met. And I think those are grounds to dismiss the case.
Okay, thank you for that. I just wanted to get some clarity, and I'm not disagreeing with me in terms of what you said I had said in earlier orders or dissents or concurrences. So thank you.
Thank you.
Thank you, Mr. Chairman. Thank you, Commissioner Beverly. Mr. Nair, good morning.
Good morning.
In your testimony, I think you said that the company's investments in your office's view were not related to the city's climate goals. And I think Ms. Curry said that some of the investments were related to the anticipation of transportation electrification, electrification of homes and multifamily buildings, the increased deployment of DERs. I'm trying to square the two statements that the two of you have just made within the last hour. Do you believe that the company doesn't need to make investments in order to, or that the investments, I think you said, were just, it seemed like they were replacing like for like or business as usual?
90% of the investments are business as usual. So there's a very small sliver of investments that could be, could be helpful for some sort of, path forward. But again, when we ask, what are those investments tied to, what specific objective, and the company had the opportunity, they could not tie those to specific investments then. I can't speak to what PEPCO says today at the legislative hearing, but when we had over the past months and we issued discovery, we didn't get a specific answer correlating the investments to specific climate goals. But more importantly, the question also is that can that 10% be accomplished through a traditional form of rate making, where you're not going to have all the problems that are going to be coming forward with this multi-year rate plan? And I would say that I think would be a better approach.
Has your office taken a position, if we looked at a traditional form of rate making, looked at a one-year case has your office taken a position in terms of how much you think PEPCO should be awarded in a 1 year?
No, we have not.
Okay.
Not at this time.
I think I'll accept that. Thank you.
I just wanted to take one brief opportunity to address administrative efficiency and regulatory lag. Basically, the company stated that there was going to be $29 million of regulatory lag. And when the actuals came in, we found out that that wasn't true. And in terms of administrative efficiency, I mean, this case has been going on for near 16 months. I don't see how it's administratively efficient. And even when we tried to participate in the reconciliation filings, it creates more work for the commission to then have to sort out the comments and give direction. And there were a whole host of problems. So in terms of administrative efficiency, I don't see that argument carrying the day at all. And council did mention Maryland quite frequently, a few times, but they neglected to mention 9702 and order 91181, 91181, in which their petition for a multi-year rate plan was denied on similar facts as that present here. So thank you.
Thank you, Mr. Nayar. If you could just please identify yourself.
Sorry.
No, when you come to the podium, just make sure you identify yourself and spell your last name for the record, please. Ms. Francis, would you prefer to sit?
I would.
Oh, then that's more than likely.
Thank you.
More than fine. Sorry.
Not for the record, but during the Exelon Pepco merger, I broke my back. So since then, it's been a little challenging to stand for long periods of time.
I completely understand. And
Sorry, is it on now?
we can just hold a little bit closer, maybe lean into it.
Okay. Can you hear me now?
Yes.
Okay. Good morning, Chairman Thompson, Commissioner Beverly, Commissioner Trabue. Pepco's second-year rate plan proposal must be rejected. The pilot multi-year rate plan did not yield the anticipated benefits. Rather, it has primarily served the interest of Pepco and its shareholders at the expense of DC ratepayers. Pepco's actual expenditures since this commission's adoption of the pilot MYP have departed substantially from its budgeted O&M cost by account and its budgeted capital cost by project. In essence, this commission is being asked to set rates on the basis of budgeted cost for a utility that has demonstrated its inability to forecast its future expenditures with reasonable accuracy. AOBA recognizes the concept of emergent costs. However, where emerging costs become major drivers of a utility's actual expenditures, setting rates on the basis of highly unreliable forecasts is not well advised. The MYP process to date has required no accountability by Pepco for either its actual expenditures or the net benefits that those expenditures provide district ratepayers. Moreover, as discussed in AOBA's limited brief, the level of capital spending built into Pepco's MYP proposals in this proceeding is excessive and not sustainable. Pepco's forecasted budgets represent a direct challenge to efforts to maintain the affordability of electric service for all district ratepayers, not just low-income customers. The affordability of electric service in the district is a particular concern to commercial buildings that are struggling with record high vacancy rates and increased risk of foreclosures. Pepco's proposed MYP in this proceeding would create an economic drag on the district and impede efforts to revitalize the district's economy. Witnesses for OPC, AOBA, and the DC government all agree that Pepco's request for another multi-year rate plan should be rejected. We must learn from the pilot MYP and avoid repeating past mistakes on a going forward basis. In order number 20755, informal case 1156, this commission stated, I quote, Through this pilot, the commission will benefit from lessons learned to facilitate the adoption of regulations for MRP and other AFOR applications, end quote. However, PEPCO's initial application and supporting testimony in this proceeding failed to address lessons learned from the pilot MYP. In order number 21886, the commission directed PEPCO to file supplemental testimony to address lessons learned from the pilot. However, the company responded with a recitation of platitudes regarding the alleged advantages of an MYP. The company presented in formal case 1156. PEPCO presented little in terms of well-structured quantitative analysis of the impacts of the pilot MYP. PEPCO offered no quantitative, retrospective examination of actual experience under the pilot. Furthermore, PEPCO has failed to provide necessary and appropriate documentation of the mathematics of its determinations of actual and planned capital expenditures by project for its completed and projected MYP years. Although the company provides discussion of factors it considered in the planning process, PEPCO does not document either the data or calculations relied upon to estimate its future expenditures or determine the portions of multi-jurisdictional projects attributed to the district. AOPA notes that PEPCO witness Cantler presents purported actual cost for a number of capital projects that are identical to the amounts PEPCO has claimed for the same projects in Maryland. A key benefit of the multi-year rate-making process was purported to be increased transparency into the company's budgeting and long-term capital planning process. However, PEPCO's claims of transparency have proven illusory. In this proceeding, AOPA has documented dramatic differences between the composition of PEPCO's budgeted costs and the composition of the company's actual expenditures by O&M account and by capital project. For the one full calendar year addressed by the pilot MYP, calendar year 2022, AOPA has shown that PEPCO had $217.1 million of budgeted cost for capital projects on which it only spent $66.1 million. Moreover, PEPCO's actual capital expenditures in 2022 include over $102.1 million that were spent on projects which were not included in the budgeted capital costs that PEPCO presented in formal case 1156. Although PEPCO represents that it underspent its overall capital budget for 2022, the company offers no quantitative assessment of the impact that these dramatic changes in the composition of its budgeted expenditures had on the benefits that were provided to district ratepayers. AOPA submits that the cost effectiveness and the prudence of PEPCO's actual capital expenditures cannot be determined in the absence of such analytics. Unfortunately, the multi-year rate plan process has failed to hold PEPCO accountable for deviations from its budgeted cost and the impacts of such deviations of ratepayer benefits. The mix of expenditures included in the company's budget must be perceived as having a direct influence on the value of ratepayer benefits provided. Yet PEPCO has not provided the level of analytics necessary to assess changes in ratepayer values from its pilot MYP. A multi-year rate plan paradigm, which establishes rates on the basis of forecast of future expenditures, relies heavily on the utility's ability to forecast its future expenditures with reasonable accuracy, where utility forecasts of future expenditures prove unreliable, evidence-based prudence proceedings become a necessity. Comment processes are not sufficient to support prudence determination. In fact, the parties in PEPCO's Maryland rate proceeding have recently agreed to a procedural schedule for the review of PEPCO's final reconciliation filing, PEPCO's rate year 3 AIF in case number 9655, that was filed yesterday for its initial MYP that provides for the filing of direct testimony, rebuttal testimony, surrebuttal testimony, as well as hearings and briefing. This illustrates the necessity of evidence-based prudence proceedings for an MYP and the fact that MYPs do not eliminate or necessarily reduce regulatory burdens. Multi-year rate plans do not reduce regulatory burdens. Such MYPs simply change the nature of the activities that the regulators must focus on, as well as the parties. In this proceeding, PEPCO has also provided forecasted budget expenditures for its designated bridge year, calendar year 2023. However, neither PEPCO's quarterly ROR filings nor the supplemental information the company provided on July 5th, 2024, offer direct comparisons of the cost PEPCO incurred during calendar year 2023 and the cost PEPCO presented as budgeted 2023 expenditures in its rate application and its supporting testimony. The affidavit of AOBA witness Bruce Oliver, provided with our limited brief, again identifies substantial departures from PEPCO's budgeted cost that are not adequately explained and not justified. PEPCO likewise has provided no assessment of the impacts of such changes on ratepayer benefits. Further, there has been no documented collaboration with other parties in PEPCO's development and implementation of changes to its budgeted cost, and there is no transparency in decision-making related to those changes. The pilot MYP may have reduced the frequency of rate case filings, but it has not reduced the level of regulatory activity or regulatory burdens placed on AOBA, OPC, DCG, and the other rate case interveners. Moreover, the records of this case, and as well as formal case 1156, highlight the increased complexity of multi-year rate plan proceedings. Effectively, the parties have been required to litigate: 1, lessons learned from the initial MYP; 2, forecasted expenditures for multiple years of a proposed second MYP; 3, a traditional test year filing with partially projected costs, and the prudence of PEPCO's actual expenditures in one proceeding. AOBA submits that the MYP process that has been employed only serves to benefit the company and its shareholders while eroding necessary ratepayer protections. The filings to date in this proceeding are clear that PEPCO's recent experience, as well as its forecast projections, reflect negative growth in KWH deliveries and KW demands, as well as only minimal customer growth, about 0.6% per year, mostly among residential and small commercial customers. Yet in the context of comparatively static or declining units of service, PEPCO has set forth a capital spending plan that reflects rate-based growth far in excess of its projected growth in customers, sales, and demands. That uncommon combination of robust capital spending and declining KWH deliveries and KW demands necessarily challenges the affordability of Pepco's electric service in the district. The costs of electric service represent one of the largest components of operating expenses for commercial buildings. Yet Pepco's proposals would further amplify the cost of operating commercial buildings in the district. Commercial building owners, as well as their tenants, are well aware that markedly lower costs are available in neighboring Virginia. Last week, on July 23rd, the Wall Street Journal published an article titled, "DC Office Market Struggles Persist." And that article began with the following: "The Washington, D.C. office market is struggling with rising foreclosures, plunging values, and its highest vacancy rate ever. The outlook looks grim." The Wall Street Journal article reports that as of the first quarter of 2024, 39% of loans for office buildings in D.C. that were securitized were either in default or at risk of default. The Washington Journal also reports that creditors foreclosed on 12 district office buildings so far this year, end quote. Additionally, the article asserts that federal agencies are expected to give up close to 600,000 square feet of presently leased office space in the district. In addition, the article observes that the weakened state of the commercial real estate market in D.C. has contributed to a substantial drop in real estate tax collection, as well as a $500 million budget gap for the district government. Finally, the Wall Street Journal concludes the district's office is poised to get worse. The Wall Street Journal on the status of the district's office market, that's not very common. And the fact that such a financially focused and respected newspaper would find cause to attribute an entire article to the plight of our DC office market gives emphasis to the seriousness of the problems that the district currently faces. In this environment, Pepco's expenditures must be more significantly constrained. If rates are to be established on the basis of forecasted cost, the detail of the company's forecasted budgets must be more closely scrutinized, and this commission must require Pepco's actual expenditures to closely conform with budgeted costs. The commission must also act to require Pepco's accountability for the cost effectiveness and prudence of its actual expenditures. Pepco must bear the burden of demonstrating the prudence of its expenditures. The burden must not be shifted to interveners who may not have the resources to engage in detailed examination of Pepco's spending and the operations outside of a rate case. The problems associated with the magnitude of Pepco's revenue request under its proposed MYP are magnified by the dramatic increase that the company seeks in its authorized ROE. Pepco's currently authorized ROE is 9.275. However, Pepco asked this commission to increase its authorized ROE to 10.50. That's an extraordinarily large and unjustified increase. As interest rates declined over the past decade, reductions in Pepco's ROE only reflected a portion of the change in interest rates. Yet now, in the context of interest rate increases, Pepco seeks a dramatic upward adjustment to its authorized equity return that AOBA submits is unnecessary and unjustified. I believe earlier this morning, Ms. Curry, on behalf of Pepco, made mention that its ROE should not be reduced. Just to note, the Maryland Commission, in its June 10th order on Pepco's multi-year rate plan, which was denied, also reduced Pepco's ROE. That order number is 91181. In that order, the Maryland Commission rejected Pepco's request in that proceeding for an MYP and for their authorized and to increase their ROE to 10.5. They lowered their requested ROE from 9.55 to 9.5. The Maryland Commission found that Pepco's requested 10.5 did not reflect current market conditions, did not conform to the Commission's gradualism precedent, and was unsupported by the record in that proceeding. Given the record with respect to Pepco's ROE request in this proceeding, it's in many ways very similar to their filing in Maryland, case 9702. It's difficult to perceive that Pepco's 10.50 request, in this case, should be found just and reasonable. AO believes this commission should approve an ROE for Pepco in this proceeding that's no greater than the company's currently authorized ROE of 9.275. The traditional test year filing provided by Pepco in this proceeding in response to the Commission's directive in Order Number 21886 was designed by the company to make a traditional test year approach to setting revenue requirements appear less attractive than its MYP proposals. The company's traditional test year revenue requirement, as presented by Pepco in its October 16, 2003 supplemental testimony, is purportedly based on 6 months of actual and 6 months of projected expenditures for calendar year 2023. However, an examination of the supporting detail for Pepco's traditional test year cost reveals that Pepco's projected cost for the last 6 months of its traditional test year are heavily loaded with cost increases beyond the level of cost actually experienced by the company in either the first 6 months of calendar year 2023 or the months of the prior calendar year 2022. It's important to recognize that nowhere in this proceeding to date has Pepco updated its traditional test year revenue requirement to reflect actuals for the second half of calendar year 2023. In addition, the projected capital additions that Pepco presented in its traditional test year filing far exceeded the actual capital additions for 2023 that Pepco now reports. In fact, Pepco's reported actual rate base for 2023 in its June 24, 2024 revised Q4 2023 ROR filing was only $2.653 billion, where the company's October 16, 2023 traditional test year filing reflected a 2023 rate base of $3.023 billion. In other words, Pepco's traditional test year filing overstates its 2023 actual rate base by roughly $270 million, or more than 10%. Pepco's October 16th traditional test year filing reflected 2023 operating expenses on a DC adjusted basis of $529 million. However, its revised Q4 2023 ROR filing shows 2023 operating expenses of only $503 million, suggesting the company's 2023 operating expenses in its TTY filing were overstated by more than $26 million, about 5%. Such inflated representations of traditional test year cost totally undermine the value of Pepco's TTY filing and the concept of traditional test year rate making. In fact, Pepco has failed to demonstrate a pressing need for additional revenue in this proceeding at this time. Although Pepco's most recently quarterly ROR filing for the first quarter 2024 suggests a limited need for additional revenue, the ROR calculations Pepco presents in its ROR inappropriately presume that all of the company's costs have been prudently incurred and that claimed gap-related reserves for rate schedule GT, LV, BSA revenue deferrals are reasonably and appropriately computed, a presumption that we specifically dispute. ALBA also asked this commission to observe that PEPCO's claimed revenue deficiency for calendar years 2021, as set forth in PEPCO's March 31st, 2022 reconciliation filing, is premised on the company's assessment of a revenue deficiency for the entire calendar year. PEPCO's representations regarding 2021 revenue deficiency that completely ignores the fact that new rates did not become effective until July 1st, 2021. District ratepayers have no responsibility for claimed revenue deficiencies associated with the company's operations prior to the effective dates of the new rates approved by the Commission in FC 1156. In order number 22013, the Commission directed PEPCO to demonstrate the prudence of its calendar year 2023 capital and operating expenditures. However, PEPCO's July 5th, 2024 supplemental information filing falls well short of providing that demonstration. The composition of PEPCO's actual 2023 expenditures has deviated substantially from the partially forecasted dollar amounts presented in its October 16th traditional test year filing. PEPCO's 2023 expenditures also deviate substantially from the fully forecasted dollar amounts presented with its application and in its rebuttal testimony in its 2023 MYP bridge year. As recently as order number 22013, this commission directed PEPCO to demonstrate the prudence of its actual expenditures. PEPCO has totally failed to provide that demonstration. The need for detailed reconciliations and demonstrating of prudence of actual expenditures continues as long as rates are set on the basis of forecasted costs. Still, there's been no demonstration of the prudence of any or all of PEPCO's actual 2023 expenditures with either formal case 1176 or formal case 1156. There is no basis for this commission to accept PEPCO's quarterly ROR filings for either 2023 or the first quarter of 2024 as reasonable, accurate, and appropriate assessments of the company's earned, returned, and revenue deficiencies for those periods. PEPCO's traditional test year filing is also highly problematic. At this point in the proceeding, there is at best substantial uncertainty regarding the traditional test year costs on which a traditional test year revenue requirement would be established. PEPCO has filed new earnings statements for 2023, the traditional test year, based on data calculations that the parties we're unable to identify them. Moreover, PEPCO's responses to data requests regarding its July 5th supplemental information filing only further highlight the difficulties associated with reconciliation of the company's actual 2023 expenditures with its traditional test year rate filing. Without further support for and verification of that information, PEPCO's ROR filings should not bias the Commission's rulings with respect to the pending dispositive motions. For these reasons, AOPA reiterates that PEPCO's quarterly ROR filings in formal case 1156 cannot be relied upon without further scrutiny and warrant no weight in this Commission's determination regarding the motions. AOBA submits that the elongated nature of this proceeding is primarily attributable to errors and deficiencies in PEPCO's own filings, and this commission should feel no obligation to assist the company's efforts to obtain revenue increases when the company itself has been the greatest obstacle to timely litigation of this proceeding. Rather, the support for this commission's rejection of both Pepco's MYP application and its traditional test year is compelling. Finally, if this commission elects not to grant the March 12th and the June 10th motions to dismiss and/or the company's traditional test year, AOBA submits that this commission must schedule evidentiary proceedings to establish a record on which a multitude of contested issues of material fact can be resolved. This is a particularly critical period for DC and its regulation of district utility services. AOBA asks this commission to reinforce its protection of ratepayer interest in the rate-making process and deny Pepco's efforts to establish, on the basis of demonstrably unreliable forecasts and excessive rate of return request. AOBA submits that the commission's only option at this point to protect ratepayers is to reject both the company's MYP and traditional test year filings. And in my minute and a half left, I would like to address something that Ms. Curry said earlier today. Ms. Curry spoke about the calculated BSA revenue deferrals for the GTLV rate class. Our limited brief states that Pepco's calculated BSA revenue deferrals for the GTLV rate class, they are overstated. We submit that Pepco's BSA revenue deferrals for rate schedule GTLV reflect a flawed methodology. The methods used by the companies to employ revenue per customer amounts that are the product of Pepco's use of incorrect billing determinants in its design of rates and yields non-cost-based assessments of allowed revenue by class when the numbers of customers in the GTLV class deviate from the numbers assumed by the company in its rate design computations. Lastly, Ms. Curry made mention that the Maryland Commission approved BG&E's MYP, even though lessons learned hadn't been completed. That was one of the reasons the Commission rejected Pepco's MYP in case 9702 last month, because lessons learned had not been completed. Further, the Commission in that order directed Pepco with its next rate case, which could be any type of its choosing, a multi-year rate plan or a historical test year rate case, to make sure they filed, along with that filing, data that the Commission could compute a traditional test year. I think I'm out of time.
Thank you, Ms. Francis. I'm going to begin close to where you ended, basically where you stated that if the motions to dismiss were denied, that an evidentiary hearing had to be held to discuss material issues of fact. And so my question is, what would be AOBA's material issues of fact that give rise to an evidentiary hearing? Not just facts that are contested, but material issues.
Listen, I hate to devise something on the spot, and I haven't drafted that letter, but just clearly from what I discussed today, what is the rate base of Pepco? That's a material issue of fact. Without knowing what the rate base is, how do we compute anything? Another issue of material fact, what are the O&M expenses? That's another issue of material fact that I alluded to throughout my argument. So in filing those motions, I never meant to, it was not AOBA's intent to foreclose further evidentiary proceedings where all of those issues could be laid out. I am at a little bit of an advantage from others in this room, other than Pepco, because we just finished litigating Pepco's MYP proceeding in that jurisdiction. And there were multiple witnesses. There were many questions, many facts needed to be flushed out. And there was a 6-day hearing in that proceeding. There are 5 commissioners, all of them ask a lot of questions. There's also a staff that puts on testimony. Proceedings are a little bit different there than they are here. But what came out on the witness stand, I believe, was truly helpful to the commission in issuing the decision that it did.
Thank you. Very quickly, one of the statements that undergirded majority of your testimony, as well as some of the other interveners, as well as OPC, is this idea of the lack of transparency, as you guys say in the MRP. Do you have any recommendations as to what can be done to improve transparency in MYPs?
Again, I don't want to devise something on the spot. However, what I have seen so far from PEPCO in formal case 1156 and formal case 1176, the MYPs that they have filed should be not continued because they have shown an inability to forecast accurately. So the first thing you need is a utility that can forecast accurately, both its capital spending and its O&M spending. Another thing, what we really need also are some guidance from the commission in what should be in a prudence determination. Because if PEPCO is going to move projects in and out of what they're doing in a different year, replace them with projects we haven't seen, just move things around at will that the ratepayers haven't seen, that the parties or the commission hasn't seen. We need a standard for a prudence review. And as well as a standard, we need a prudence review proceeding, just like we've established in Maryland. The way the Maryland Commission worked, the first 2 prudence reviews were part of a base rate case, were part of the rate case we just litigated, and the final reconciliation is part of a whole new rate reconciliation proceeding, just a normal evidentiary proceeding that we do. So you would definitely need prudence standards. And once you start with mini rate cases over prudence and reconciliation filings, that's a mini rate case, which does certainly not reduce regulatory burdens. So I heard, Ms. Curry say this morning, they have not done the analysis of the cost of a MYP and the costs of a traditional rate case. But I haven't seen any reduced regulatory burdens. And, one other thing, I think the commission's requested the PIMS. There were PIMS working group, and AOBA had a consultant, and along with OPC, we were directed by staff to write that working group report. That working group report, I believe, was submitted to the commission last November. So I haven't seen any work group proceedings regarding the PIMS on an ongoing basis since we filed that final report. But again, if we're going to do another MYP, got to have some PIMS, as that's what the commission originally decided. But basically, you need those prudence reviews, and you need hearings on the reconciliations, because how do you know with what PEPCO is moving around, how do you know that it's prudent? And how do you know the cost, if it's going to cost the ratepayer X amount to do project 1, 2, 3, 4, how much is the ratepayer going to save by the company doing project 5, 6, 7, and 8? We have no information of that. PEPCO has just moved projects in and out of its multi-year plan. And what we have is a spending plan for PEPCO. That's all it is. And there's no prudence at this moment.
Thank you. My last question is going back to the BSA, because we certainly heard the company talk about the financial health of the company, and then you did gave a recitation of the commercial district in the district, and to me that's just as important, right? The commercial district is a huge tax base, and really would just want to hear your impressions of the BSA and how it's worked for the commercial class, especially coming out of COVID.
Terribly. It works terribly, and it hasn't worked. And I don't mean to be flip. It hasn't worked for several years. You just an example. We did a review, my consultant did a review of a comparison of the BSA for the GTLV class. And under the actual under recoveries for the BSA class was $12.9 million. PEPCO shows an under recovery for GTLV of allowed revenue of over $64 million. There is substantial, we believe PEPCO's methodology is flawed. So they're used wrong billing determinants, their methodology is formed, and then we get a disparaging, a major difference between $12.9 million, which we believe are the actual under recoveries, and what PEPCO claims are the under recoveries of $64 million. I can't reconcile those numbers. It's PEPCO's flawed methodology. And of course, how the BSA works would be subject to review in an evidentiary proceeding.
Thank you.
With regard to an inaccurate forecasting, do you believe that that issue is more significant in an MYP than it is in traditional rate making, or you think it's the same?
Inaccurate forecasts, without an accurate forecast, there should be no MYP. This company has shown it is incapable of doing an accurate forecast. So without that, I can't think, that's where you have to start. That's the whole basis of an MYP, are based on accurate forecasts. And as OPC said this morning, the forecast, the data for 2023, you can't reconcile it with their projected costs. So without accurate data, you're nowhere in terms of an MYP.
Okay. With regard to cost containment, have you seen in another jurisdiction anywhere where
I'm sorry, I can't hear you. A little bit louder.
with regard to cost containment, have you seen something in other jurisdictions that include an element in an MYP that specifically addresses that, so that there's some mechanism within the plan itself to handle cost containment?
I think PEPCO's feet should be held to the fire. I don't think they've come close to justifying $190 million worth of rate increases over the next 3 years. So I think especially, or the $108 million for a traditional test year. I think that considering the economy of the District of Columbia and the affordability of rates are important considerations for this commission. And I feel that when you have declining KW and KWH deliveries in the face of 0.6% customer growth, I think PEPCO's capital spending and trajectory of O&M cost needs to be reined in by this commission.
Good morning, Ms. Francis. Thank you very much for your testimony today. What is AOBA's view on looking more towards a traditional sort of a rate case, a one-year case versus a multi-year case?
But what is AOBA's view on?
Looking at a one-year case, a traditional case versus a multi-year case for the matter that is before us today.
AOBA is, from what we have seen to date, we have a strong preference for a traditional test year because of our past experience with PEPCO in the past 2 MYP proceedings, and also in the PEPCO Maryland proceeding as well. So we would have a strong preference for a historical test year. However, we don't believe that PEPCO has shown a need for a revenue increase in this case. So in this case, I'm not in favor of granting a traditional test year because the data doesn't support an increase. That doesn't mean PEPCO can't turn around and file another request for a traditional rate case upon the conclusion of this case. But I don't think the record supports that here.
Many of the parties here have discussed the need for a good lessons learned scenario. Your organization operates in a number of states throughout the country, does it not?
We try cases in Pepco, Maryland. We try cases in the district, as well as Virginia Power and Washington Gas in Virginia. I don't do BG&E cases.
Okay. Do you have some best practices that you might be able to share with us from those experiences elsewhere in the
We
country?
have not seen MYPs in Virginia. We have not seen MYPs with Washington Gas. So I do know about them in BG&E. The utilities that have them in Maryland are all Exelon utilities. So I personally have not appeared in another MYP case other than Pepco, DC, and Maryland.
In your filing, was there a discussion of the increase to residential rates in the distribution charges?
I think Pepco's rate increase and their requested ROE is excessive. So I think that needs to be substantially lowered. However, as this commission knows, and it is in our direct testimony, that there is an enormous subsidization between the commercial class and the residential class. I believe it's over $100 million. I don't have the number on the top of my head. So I do believe that while we don't challenge the benefits that the low income and elderly and disabled and senior citizens get in terms of that portion of the residential class, we do think the other portion of the residential class that's not low income should bear a lot more of its responsibility than it does. And that those gaps need to be narrowed.
Right. I think an increase by $1 a month in the initial year was suggested. Oh,
No,
not by you, but maybe by the company. But has your organization taken a position as to how much that increase on the non-low income customers, how much of an increase might be suitable?
We haven't filed testimony on that. Once the commission lowers Pepco's revenue request, if they decide to grant any revenue request, then I think the numbers should be looked at carefully for each class. But I do think there should be a narrowing of the class rate of return differentials. Keep in mind, right now, whenever the company gets a new residential customer, whether it's an individually metered apartment house or a new residential homeowner, the company loses money. They are providing a negative rate of return. So I know, the people here, there's going to be a push for whatever commercial office buildings can possibly convert to an apartment building. I know people would like to see that happen. I know because the mayor said so. A little bit more difficult than I think people realize, but every time you sign a new residential customer in an individually metered apartment, the company's losing money. And as the declining KWH and KW for office buildings, who's going to pay for that? Who's going to pay for it?
Thank you very much.
I'm sorry, I do have one question. I want to follow back up on Commissioner Beverly's question, because he asked you about cost containment models. And I think your answer really spoke to overall cost, right? And
Correct.
I believe, please correct me if I'm wrong, I think, well, let me say, what I'm interested in is if there is a rate increase and, for sake of argument, to MRP, what type of cost containment should be imposed on the company to make sure that their forecasted or their budgeted expenses are as close to whatever we approve on that budget? What kind of guardrails can we put around that?
I think the commission needs to sharpen its pencil. I think that You ought to look at the capital budgets. You ought to look at the capital budgets along with what you see in growth in numbers of customers and the decline in usage. And as someone made mention to, Pepco is top quartile in their SAIDI and SAFE, and determine what level of spending is really, really necessary right now.
So let me ask the question a different way. 'Cause
I mean, I can't give you a number. I mean, I
Okay.
could get my consultant to say something, but
So let me give you I think a hypothetical. I believe Ms. Curry came up earlier and she said, "Oh, well, part of the reason why there's so much variance in our construction costs are because we have a 50% band, and then as it goes along, they narrow it." To me, that's a very wide band. If I was going to have some construction done in my house, I would need a tighter number than a 50% band. So, is there an industry practice, perhaps, and again, maybe that's a question for an expert, but is there an industry practice around what an acceptable variance should be versus forecasted versus actuals?
I'm not sure. What is I didn't hear the last part.
Is there an industry standard around forecasted versus actual spend? The variances, yeah.
An industry standard in the commercial building
Not
industry?
necessarily a commercial building, but in construction projects with utilities.
Oh,
that
the
you
construction projects of my members, that's beyond my,
Okay,
my, I can't answer that.
Okay. Thank you. All right. Thank you, Ms. Francis.
I want to thank the commission, and thank you for your questions.
Can you hear me? Yep.
Good afternoon. Good afternoon.
Good afternoon now. Commissioners Beverly and Trebu and Chairman Thompson. I'm Senior Assistant Attorney General Brian Caldwell with the Office of the Attorney General, representing the District of Columbia government in this proceeding. The district generally echoes the comments from councils for OPC and EOBA. I'm here today to discuss in greater detail the two issues identified in the district's pre-hearing brief as being fundamental as to whether or not Pepco's MRP should be approved. I start with the standard caveat that these are two issues do not encompass all the issues that are important or even fundamental from the district's perspective. The district intends to address those issues fully in its post-hearing brief. The first issue that we raised as being fundamental was that the MRP should be denied because no comprehensive review of the modified EMRP pilot was ever conducted. To the extent the EMRP pilot, EMRP being enhanced multi-year rate plan, pilot was, to the extent the EMRP pilot was addressed in this proceeding, there is no basis to find that the EMRP provided any benefit to district customers or advanced the district's climate or clean energy goals. In order number 20273, issued in formal case 1156, the commission established a framework for alternative forms of regulation, or A4s. The commission determined that any proposed A4 must have measures in place to protect consumers, ensure quality, availability, and reliability of regulated services, and ensure that the A4 is in the public interest. Importantly, the commission found that a properly designed A4 could provide a new tool to further the district's ambitious clean energy goals and the commission's Power Path DC objectives, while also preserving a high standard of energy delivery system reliability and fostering grid modernization. Pepco's modified EMRP was eventually approved by this commission on a pilot program basis. However, the commission did not adopt a formal evaluation plan or establish A4 regulations after approving the modified EMRP on a pilot basis. It was not until after Pepco filed its second multi-year rate plan in the instant proceeding and in response to comments from the district and other parties urging the PSC to adopt a procedural schedule that would facilitate a comprehensive review of the pilot that the commission directed Pepco to file supplemental testimony with accompanying exhibits that explain in quantitative and qualitative terms the benefits of problems identified and lessons learned from the pilot program. In its order, it approved the modified EMRP as a pilot, which is, quote, an activity undertaken as an experiment to determine if something should be pursued more broadly, end quote. The commission stated the information contained in the supplemental testimony will support an assessment of lessons learned from the modified EMRP and develop an evaluation framework in assessing PEPCO's second MRP as proposed in this case. Respectfully, the approach taken by the commission to assess the modified EMRP was problematic. Relying on PEPCO to provide a self-evaluation of its modified EMRP without the directives from a formal evaluation framework does not provide sufficient information to assess whether the modified EMRP successfully achieved the goals of alternative forms of regulation. Instead, PEPCO's self-evaluation was merely a litany of self-serving claims that cannot be verified. In formal case 1156, in response to the commission's order on alternative forms of regulation, the company identified 10 incremental benefits or goals that the modified EMRP would provide, but none of these benefits actually materialized. The first benefit allegedly that would come from the EMRP was it would facilitate investments that support the district's energy policies. However, PEPCO does not track these investments in its EMRP and does not demonstrate that the investments that were made would not have occurred under cost of service regulation. Second, the modified EMRP would provide customers, the commission, and interested parties a longer-term view of future capital investment and O&M plans before it's operation and maintenance plans before the utility makes those investments. But information asymmetry and the opaqueness of PEPCO's capital investment strategy limits the usefulness of these plans. Further, as will be discussed later in my presentation, the list of investments is not tied to an integrated distribution plan or a grid modernization plan. Had the proposed investments been tied to such plans, the parties would have been provided with a full analysis of alternatives and important context for the investments. Third, the modified EMRP was to provide customers with rate predictability over the MRP's term. Rate predictability is achieved through guaranteed increases to PEPCO's revenue requirement, which primarily benefits PEPCO by shortening the cost recovery period of its investments and reducing the likelihood of cost disallowances. Fourth purported benefit of the modified EMRP was to provide a decrease in the administrative burden and cost for the commission and stakeholders by reducing the frequency of annual rate case filings. PEPCO did not provide any specific measurement of this purported benefit. Fifth, the modified EMRP would protect customers and provide incentives to the company to reduce costs and improve operational efficiency through the proposed annual reconciliation filings. But as DCG witness Courtney Lane discusses in depth in her testimony, reconciliation of overspending shifts risk to ratepayers compared to cost of service regulation. And reconciliation of underspending, in other words, returning cost savings to ratepayers, severely erodes PEPCO's incentive to reduce costs. Sixth, the modified EMRP was to better align customer rates and reflect the current cost of providing service to customers through annual reconciliation process. But again, as DCG witness Lane testified, the reconciliation process does not guarantee that the costs embedded in rates are optimal. Further, it reduces the incentive to PEPCO to control costs and find alternative low-cost solutions like non-wires alternatives. Perhaps that is why no other jurisdiction in the country besides DC currently has a multi-year rate plan in effect with annual downward and upward reconciliations. Seventh purported benefit of the modified EMRP was to increase the level of transparency and reporting to customers, the commission, and stakeholders. But as I discussed in my brief, and will address later on, the data provided is of relatively little value in the absence of a integrated distribution plan and grid modernization plan. 8, the modified EMRP would enhance commission oversight through advanced review of the company's total capital investment plan and proposed performance levels with annual reporting and reviews of certain variances to those approved plans over the term of the MYP. Again, at its conclusion. For similar reasons as purported benefit number 7, the company's total capital investment plan with annual reporting and reviews of certain variances to approved plans provide little additional meaningful improvement to transparency. Ninth, the modified EMRP would provide for significant automatic financial penalties if the company did not meet commission-approved performance criteria, but PIMs with financial penalties were not adopted in conjunction with the modified EMRP. And finally, 10th, the modified EMRP would enhance certainty of spending for the plan's term, leading to improved investment planning that would create jobs and promote economic development. But there is nothing special about spending pursuant to the modified EMRP that creates jobs and promotes economic development. These outcomes could just as easily be achieved through investments resulting from traditional cost of service regulation. Moreover, this benefit could also be achieved through limited cost riders or trackers for specific types of investments like grid modernization investments. Of particular interest to the district was the company's representation that the structure of the modified EMRP allowed for the company to invest at the pace required to meet the district's and the commission's decarbonization and clean energy goals and support investments that are foundational to a climate-ready grid, such as those that maintain reliability and resiliency. But the company did not provide or identify any investments that specifically support the district's energy policy goals. The company states that it does not track investments by whether they meet a specific decarbonization or clean energy goal. So when asked to list the reliability and resiliency investments made during the modified EMRP pilot period that directly support the district's energy goals, the company was unable to do so. This is problematic because one of the primary justifications for implementing alternative forms of regulation is to facilitate investments that support the district's climate and clean energy policy goals. The primary driver of a multi-year rate plan is to support these policy goals. The company would be transparent about them in this regard. In fact, the company cannot identify any such investment, reveals the empty, self-serving nature of these statements. In short, the purported benefits that would flow from approval of the modified EMRP either did not materialize or could have been achieved just as easily through traditional cost of service regulation. And although the company states that the modified EMRP, quote, generally achieved the qualitative and quantitative benefits, end quote, there's insufficient data to assess the merits of PEPCO's self-evaluation. When asked to provide the work papers, data, analysis, assumptions, and studies, as was discussed earlier, that PEPCO relied upon to quantify each of the benefits achieved by the modified EMRP, PEPCO indicates it did not quantify the dollar value of each of these incremental benefits. Nor could PEPCO provide any quantitative data to demonstrate that the modified EMRP provided benefits to customers or achieved public policy goals. The company, again, indicated that it did not perform this analysis. Without reporting metrics and quantitative data to back up PEPCO's claimed benefits of the modified EMRP, there is no factual basis to find that the alleged benefits of the modified EMRP were not outweighed by the harm caused from information asymmetry combined with the erosion of incentives to contain costs inherent in traditional cost of service regulation. The Commission should find that the EMRP pilot was a failure and should not be continued through the instant MRP application that PEPCO's filed in this case. The Commission should return to traditional cost of service regulation of PEPCO's rates until such time as the company can submit a multi-year rate plan application that can demonstrate in concrete, quantifiable terms how that plan will achieve the goals set forth in the Commission's alternative form of regulation order. The second issue that was fundamental to the district in the brief that we submitted was that PEPCO's MRP should be denied for the additional reason that PEPCO has no integrated distribution plan in place with a grid modernization component to put the MRP's proposed capital investments into context. Without a non-wires alternative PIM in place, PEPCO has little financial incentives to consider low-cost climate-friendly alternatives to traditional capital investments. A non-wires alternative PIM should also be developed in conjunction with a integrated distribution plan and grid modernization plan. PEPCO's distribution planning process remains opaque, facing the Commission and stakeholders to rely on unverified assertions by PEPCO of its capital investment needs. One assertion that is demonstrably false, however, is that the MRP will help the district achieve its climate and clean energy goals. PEPCO refers to its MRP as a, quote, climate-ready pathway, end quote. However, PEPCO's MRP is not a climate-ready pathway, instead uses the guise of supporting the district's climate goals as a means to increase business-as-usual investments that do not adequately advance the district's energy and climate goals. Indeed, the company does not identify specific investments as being part of the climate-ready grid. When asked to identify projects in PEPCO's distribution construction program report included as Exhibit PEPCO H-1, the company did not provide a list. Instead, PEPCO states that its capital investment strategy during the MRP will, quote, focus on supporting a pathway to a climate-ready grid through, amongst other things, improving grid resiliency, end quote. But it is unclear how the company proposes to improve grid resiliency. PEPCO states that, quote, witness Cantler's testimony and attachments primarily cover reliability investments to maintain PEPCO's distribution grid or the platform for the climate-ready grid. The company's plan to improve resiliency to address the impacts of climate realities includes the replacing of aging and obsolete infrastructure and routinely and timely performing corrective maintenance work where necessary. But these are activities that are core to the traditional duties of an electric distribution company. PEPCO has not adequately explained why undertaking these traditional goals would justify an MRP. It is unclear what portion of this undefined climate-ready grid is supported through MRP investments versus investments proposed in other proceedings. As the company notes, there are other proceedings that support the climate-ready grid, including formal case numbers 1167, 1130, and 1160. The expected benefits from investments associated with the climate-ready grid appear to be the same as those that would result from traditional utility investments that have historically been sufficiently supported through cost of service regulation. Specifically, PEPCO states that the anticipated benefits include, quote, providing customers with a safe, affordable, and reliable energy system, end quote. While these are important goals, they do not differ from PEPCO's historical mandate. Nor has PEPCO developed metrics to track the benefits or deployment of a climate-ready grid. PEPCO has not identified which investments are part of its climate-ready grid or what associated costs it would recover through the MRP, nor has it identified quantifiable metrics to measure the benefits associated with these investments. This lack of transparency is counter to one of the purported goals of the Commission's A4 framework, which is, quote, to provide an appropriate level of transparency and reporting into the utility's operational and capital plans, end quote. Similar to PEPCO's exaggerated characterization of its MRP as a climate-ready grid are the claims that capital investments are necessary to support impending electrification. When asked to provide the company's forecast of the anticipated growth in electrification, PEPCO indicated that it does not directly include electrification in its 10-year capacity load forecasts. This is problematic because the company is asking the Commission to approve a revenue requirement for the MRP term that is based on the need to create a climate-ready grid to prepare for the, quote, significant shift to electrification, end quote, without considering actual electrification forecasts or conducting an analysis to determine whether additional distribution investments are actually needed to support forecasted increases in electrification. PEPCO's planning process should be modified to address alternatives to traditional utility investments. PEPCO should evaluate the cost effectiveness of alternatives to traditional distribution assets, and it should present those results as part of a detailed distribution plan that includes location-specific analyses of load growth and capacity needs on the distribution system, as well as the cost and benefits of various approaches to addressing the growth is also needed. This is a critical missing piece from PEPCO's MRP. The company does not base its proposed investments on a comprehensive integrated distribution plan that integrates distributed energy resources, or DERs, and adequately considers non-wires alternatives as means to provide the least cost solution to ratepayers while supporting a reliable and resilient electric system. The Commission should not approve an MRP until PEPCO develops an integrated distribution plan. Indeed, from the district government's perspective, an MRP just doesn't make sense in the absence of an IDP. Without this tool, it is impossible to assess the reasonableness of any individual planned investment in PEPCO's MRP distribution construction plan. An IDP places individual investments into the context of an overall plan. If PEPCO wants ratepayer funds in advance of making its capital investments, as its MRP provides, PEPCO must be able to demonstrate and explain to the Commission and stakeholders how each individual planned investment fits together as well as into the overall distribution plan. PEPCO's MRP does not do this. The best fix for these informational deficiencies is requiring PEPCO, in conjunction with an IDP, to provide a grid modernization plan, including a benefit cost analysis, or BCA, of its proposed grid modernization investments. A comprehensive grid modernization plan would include a systems need assessment, technology investment roadmap, timeline, and a benefit cost analysis that adheres to the framework to be developed in accordance with Commission Order number 21938, issued on December 8, 2023, in General Docket number 2019-04-M. It is important that PEPCO incorporates its grid modernization investments into its distribution planning. This plan should also include an account of PEPCO's grid modernization actions to date, active proposals, and future plans in a detailed and transparent format. All planned investments should be included in this plan, including those investments already proposed in other proceedings. Further, PEPCO should detail in this plan why its investments are the optimal ones to achieve relevant district policy objectives, detailing the specific benefits that are expected to arise for each of the planned investments. While PEPCO does include some grid modernization projects in its MRP, it is difficult to discern the complete set of grid modernization investments proposed by PEPCO. While the district is generally supportive of PEPCO's grid modernization investments, the district has concerns about PEPCO's approach to presenting these investments in its MRP filing. PEPCO's presentation of these investments lacks transparency and clarity. Also, PEPCO has omitted key information that is critical to evaluating its grid modernization plans. For example, PEPCO does not explain how individual grid modernization components fit together, nor does PEPCO comprehensively evaluate alternatives to its proposed plans. It is important for a grid modernization plan to be presented clearly because grid modernization is distinct from business as usual investments. Investments in grid modernization are often elective, and the value proposition for grid modernization investments usually rests on meeting policy objectives that go beyond the provision of reliable and affordable service. Moreover, grid modernization technologies are complex and interdependent. Taking all of this into consideration, it is clear that the Commission and stakeholders need a comprehensive picture of PEPCO's grid modernization program to ensure that it is in the public interest and will advance the district's climate goals. In its proposed MRP, PEPCO does not clearly map its grid modernization investments to the district's climate goals and desired outcomes. For example, the Local Solar Expansion Amendment Act of 2022 increased the already ambitious targets for distributed solar in the District of Columbia. And so it is imperative that PEPCO makes the necessary investments to enable the required interconnection of distributed solar. But PEPCO's distribution construction plan does not indicate how much additional hosting capacity for solar and other distributed energy resources will be achieved. Although the company reports that its modernization efforts will enable deployment and interconnection of distributed energy resources, there is no clear assessment of how much distributed energy resource interconnection will be facilitated through the company's grid modernization investments. And to the extent that growth in distributed energy resources are accounted for in PEPCO's load forecasts, it is not clear that the forecast is consistent with statutory requirements for solar growth. A grid modernization plan will also provide the Commission and stakeholders with greater transparency into grid modernization investments occurring across multiple proceedings. This is important because the complexity and cost of grid modernization investments often necessitate the staggering of these investments over time and across proceedings. A comprehensive grid modernization plan can help to provide transparency on the interdependencies across investments and provide a more holistic view into the overall costs and benefits to the electric system and ratepayers. The certainty and cost recovery that PEPCO is seeking through the MRP must be accompanied by greater prospective scrutiny of the investments that would effectively be pre-approved. The grid modernization plan and integrated distribution plan the district recommends would help to clarify the extent of Pepco's modernization investments and provide needed justification for the investments. Again, from the district's perspective, without these tools, an MRP simply does not make any sense. In addition, to help ensure the investments within the MRP are aligned with and advancing the district's climate and clean energy goals, any MRP must include a non-wires alternative PIM, or NWA PIM. The PIM would reward Pepco for each cost-effective NWA implemented in the District of Columbia service territory based on the present value of the net benefits from implementing NWAs procured through an open source request for proposals in which the solution type has not been pre-selected. The PIM will encourage Pepco to proactively identify all NWA opportunities, seek the least cost NWA solution regardless of whether it is a capital investment, and be rewarded for maximizing ratepayer savings. Right now, Pepco has a financial disincentive to invest in NWAs. Under the current regulatory model, the company is incentivized to prefer capital investments over operational expenditures as a means to grow its rate base and thereby profits. In fact, the incentive to undertake more capital investments is strengthened in the MRP by the reduction of regulatory lag, which allows the company to recover its costs more quickly. This means that Pepco has a strong financial incentive to meet a distribution system need with the installation of new substations, transformers, feeders, or utility-owned battery systems on which it would earn a return, rather than a third-party NWA solution that would be classified as an operational expense with no return. An NWA PIM is needed if the Commission is serious about advancing the district's decarbonization goals. The financial incentives in the existing regulatory framework are insufficient to encourage Pepco to identify and seek out third-party NWAs solutions. Within the MRP, Pepco only identifies 2 battery storage projects as non-wires solutions, both of which are based on utility-owned capital assets. A utility-owned battery system was selected to defer the need for a new substation serving Alabama Avenue, the Alabama Avenue substation, and a battery system was selected for Pepco's Mount Vernon Square substation to address projected firm capacity load. Only one RFP for a third-party NWA solution was issued as part of its distribution system planning NWA process, and no NWA solution was ultimately selected. Even though Pepco has issued limited RFPs for NWAs, it is clear that Pepco is undervaluing the benefits of NWAs. An NWA PIM is needed to create incentives for Pepco to make investments in technologies that will help the district achieve its decarbonization goals, and Pepco does not have a financial incentive to implement NWAs. It appears to be undervaluing third-party NWAs. For example, the company did not provide details regarding why the third-party NWA solution mentioned wasn't selected. It is clear a screening process does not consider the full benefits of NWA solutions. For example, Pepco does not account for the monetized value of avoided carbon emissions or consider the locational value of distributed energy resources on the distribution system when reviewing NWAs. If Pepco is not monetizing the full benefits of an NWA solution, it is not surprising that NWA solutions were not selected. An NWA PIM does not need to be developed within the context of the PIM's working group and could be developed without the need to rely on historical baseline data to determine appropriate targets and incentive levels. Instead, the NWA PIM would function based on a shared savings approach. The shared savings-based incentive would allow Pepco to retain a portion of the difference between the present value of the traditional wire solution and the NWA. For example, Pepco could be allowed to retain 30% of the savings or the net benefits relative to the traditional solution. This provides an incentive to the company while allowing ratepayers to retain the majority of the savings from the NWA. One important advantage of providing the utility with a portion of the net benefits, the difference between costs and benefits, is that it incentivizes the company to both reduce costs and increase benefits. To qualify for this incentive, Pepco must demonstrate that the NWA is cost-effective using a benefit cost analysis that accounts for all societal costs and benefits in alignment with Commission Order Number 21938, including but not limited to greenhouse gas emissions and air quality impacts, to appropriately value the role of distributed energy resources as NWA solutions. The least cost solution to identified system needs should give equal consideration to NWAs procured through open-sourced solicitations to third parties and through company-specific actions, including the targeted deployment of demand response, energy efficiency, and time-varying rates. An NWA PIM would improve outcomes for customers. It would provide an incentive to the company to seek cost-effective NWA solutions that are not owned and operated by the company. The PIM would help overcome the existing financial disincentive for PEPCO to use third-party or customer-facing DER solutions to meet a utility system need. Cost-effective third-party PIMs have the potential to reduce the need for new distribution expenditures, thereby significantly reducing costs to customers. An NWA should accompany an integrated distribution plan with a detailed grid modernization plan. Again, PEPCO's MRP does not make sense without these tools.
Thank you, Mr. Caldwell. My first question, this NWA PIN that you've discussed now, was this raised in 1156 or is this the first time it's being raised?
This is the first time it's being raised.
Okay. Just curious, yeah.
I mean, it was raised in the direct testimony of Witness Lane.
Yeah, okay.
Let's proceed.
And then a lot of what you talked about with regards to cost, in terms of MRP, you said, essentially you can't have transparency without an IDP or an IRP, depending upon how you frame it. Are there any other ways to get to transparency in an MRP without an IDP?
I mean, you could require PEPCO to provide, far more detail than it does currently in its distribution construction report. Right now it's impossible to tell really what any individual investment is doing or the purpose of it and what, the company hopes to achieve by making the investment. And that's why we recommend an integrated distribution plan, because you would be able to tell what that investment is designed to achieve and also over time.
Thank you. Those are my questions I have.
Is a stay out provision essential to the plan that PEPCO has proposed?
Is a stay out provision essential?
Right. That is, should we require it?
Yes, I believe that, the commission should require a stay out provision. That additional time between rate increases would provide the commission and the stakeholders and parties to sort of assess the relative merits of the multi-year rate plan that we just went through.
In answer to my question about cost containment, I was just sort of skimming your Witness Lane's testimony. And just from what I can gather from this, her opinion seems to be that this is the opposite. The plan that we have is the opposite of cost containment.
That's correct.
The plan has elements in it that prevent or don't incentivize a control of costs, but actually incentivizes just the opposite.
Correct.
Especially in the absence of a stay out provision. So I was just trying to understand a little bit more about that. So as I can see here, the bidirectional reconciliation that you had referred to, and like that should be just downward reconciliation and some other factors that she had identified.
Correct. The upward reconciliation erodes PEPCO's incentive to control costs in two ways. The first is that PEPCO has little incentive to find cost efficiencies because it receives no benefit from reducing its costs. And the second way is that PEPCO is better off overestimating its capital costs to ensure that it will not overspend its allowed revenues and forfeit the carrying costs associated with that overspend.
If PEPCO, I'm not saying they are, but if PEPCO overstates costs and understates revenues, and you combine that with all these other things and you approve a plan, I can imagine what the effect is on ratepayers, but Is there a way to reconcile that later? Or is this just a done deal from one rate plan to the next?
I mean, I think, without accurate cost casts combined with this it's annual reconciliations of rates, it's always going to be problematic. The rates will never be accurate because they have an inaccurate starting point, and then you have incentives or you have disincentives to control costs. So, I would say that one step the commission could take is to eliminate these annual reconciliations and make Pepco live within the budget that it's that's approved.
And with that, I'm trying to go back to what you said about a PIM. Is there a PIM that would reflect that? Would there be?
I mean, I think I recall back before the original MRP was proposed, there were a series of meetings over at Pepco that were sort of conducted by the representative from the Brattle Group who had conducted a study on, multi-year rate plans across the country. And I think there was some discussion of like, sort of like a sharing cost savings, like sharing between customers and the company. It's not exactly a PIM, but it's a sort of maybe a way to share in some of the benefits of the savings.
Incentive to control costs or to share profits, I guess.
Right. I mean,
I'm just, I don't want to put you on the spot.
and then the ROE would be adjusted according to, whether the company is over earning or under earning, in the next rate case. Again, that's not exactly a PIM, but it's a sort of incentivizes more accurate, cost forecasts and cost savings.
Okay, thank you for that. I don't have any further questions.
Thank you. Good afternoon, Mr. Caldwell.
Good afternoon.
So I think as part of your testimony, you said that the investments that Pepco is making are not tied to the district's climate goals. The district is the primary driver behind a lot of the electrification and DER efforts in the city, is it not?
That's correct.
To what extent does the district communicate with Pepco that these are the projects or these are the areas that we are exploring over the next year or two?
I mean, I think there are, the communication occurs in other dockets that the PSC has open, like 1130 and 1155 that pertain to transportation electrification.
But you specifically mentioned, DERs and, like home electrification or things that are going to make significant, variations on the load in particular areas of the city. Are those sorts of communications going on back and forth between the district and the company?
I honestly, I'm not aware of if they are, that would be through the Department of Energy and Environment, and I don't have complete knowledge.
Or is there an estimate given maybe on an annual basis or so of how much money is available to the district for electrification or solar efforts? Therefore, the company is able to plan, make some plans in advance.
How much money is available to the district for?
Yes. Mm-hmm. The district is supporting these projects financially. So I
don't,
think
I'm sorry, I don't know.
there's communications issues as I see it as a challenge. As I see it, you guys keep on.
I'm not privy to those
I think
all the communications that happen
Mhm.
between the company. Oh, sorry.
Yeah. No, it's a matter of Pepco has to do some planning in advance. They have to, plan for electrification or changes to the load, but they're not getting information, as I understand it,
Well,
about what the district has in store. That's why I say there's a communications problem. I'm not putting this on you.
No, no, no,
I mean,
I'm not trying to
it's just-
answer your
it's just an
question.
observation. I think
mean-
it's more than it is a question.
I mean, for formal case 1167, DOEE filed its strategic electrification roadmap for
Mhm.
buildings and transportation in the district, or the electrification roadmap. And it analyzed the specific load increases and timing that additional energy efficiency and electrification measures that were needed to meet clean energy DC plan. The target of 50% reduction of greenhouse gas emissions by 2032. And the roadmap sort of quantified substation impacts for summer and winter peaks resulting from adding, building electrification and electric vehicle charging onto the grid. Pepco didn't incorporate the findings of that study into its capital planning.
Okay.
That was through a data request. We confirmed that. The electrification roadmap did find the Pepco system is well equipped to handle projected electrification loads from buildings and transportation up through the year of 2032. And that the combined electrification loads are not expected to exceed substation capacity in any zone in the District of Columbia during that time period, which kind of comports with the company's own findings that system will be able to handle any additional load that would result from electrification, at least in the next 10 years.
All right.
I don't know if that answered your question, but those are forms of, communication that I can refer to that are publicly available.
Mhm.
And I know there's coordination through the Sustainable Energy Trust Fund, or Sustainable Energy Utility, I should say, not the trust fund, between, the SEU and, as your honor knows,
Mhm.
the SEU and Pepco.
Yeah.
To discuss, those sort of initiatives.
Okay.
And that SEU is overseen by the contract is overseen by the DOEE.
Absolutely. Thank you. Is it your, I don't think I heard you opine on a traditional rate case versus, the multi. Would you prefer a traditional rate case as well?
That would, in the context of the MRP that was filed in this case, definitely a traditional cost of service rate making, would be vastly preferable to the MRP that has been submitted in this case, because we feel that it's so flawed that it would not produce any benefits to customers, would really, or the district's energy policies.
All right. Thank you, Mr. Caldwell.
We have no further questions. Thank you, Mr. Caldwell.
Thank you.
I just want to check with DC Water and GSA. Didn't know if you felt so moved by the testimony today that you wanted to add anything to the record, but wanted to give you the opportunity just in case.
Thank you, Chairman. We have nothing to add.
As inspiring as the oral arguments have been, GSA also has nothing to add.
Okay. Thank you. So I will now call Ms. Curry back up to the podium for her rebuttal. You have 10 minutes.
Thank you, Chairman. Again, Kim Curry representing Pepco. OBC and AOBA and DCG, I believe as well, discussed how our plans are business as usual. And that's how it appears to them. However, our investments, for example, to harden the system, one of the benefits of that, or one of the purposes of that, is to harden against more severe storms that we expect as a result of climate change. So generally, that is how we incorporate, an example of how we incorporate climate goals and the impacts of climate change into our investments. That's just one example. Not linking it to one specific project, but the general need to harden our system for that purpose. OPC and AOBA made comparisons between the rate base in 1156 and 1176. That's not an apples to apples comparison. The in case FC 1156, what we presented were actual results with rate making adjustments, whereas FC 1176, the current rate case, is forward looking. So there's not a good sense of comparison as the parties are trying to do. Several parties talked about there being no prudency review. There is a prudency review. The commission identified one in order number 20755. You called it a reconciliation and prudency review. One exists. That process allows for, along with the annual information filings, allow for parties to ask data requests, or DRs as we call them, and for parties to file comments. OPC filed comments on the 2021 annual information filing, or AIF, but AOBA did not. AOBA did not submit DRs. AOBA did not submit comments either. So there is a process for the parties to vet or ask questions about our investments, our variances between our budgets and our actuals, but those parties have to avail themselves of that before they can ask for a change in the plan or the structure of the MYP as you've designed it. Several parties talked about filing our application with no PIMs. And someone suggested, why the utility should have waited before filing this case. Should have waited on the work of the working group before we filed. Delaying would hamper our ability to meet the district goals on an undefined or a process through the PIMS working group that does not currently, have an end or an end date. So we had to file our plan to make sure that we are making the investments that we can, again, to provide safe and reliable service as well as meet district goals. Commissioner Beverly, I think you had asked, do the parties meet on what should be in an MYP? The commission's AFOR order lists exactly what should be in an MYP. The commission's order in the company's first rate case lists what should be in an MYP. So that has already been determined by the commission. That framework is there, and it's an excellent guideline to follow for MYPs. AOPA mentioned that in 9702, I'm sorry, that is the docket in before the Maryland Public Service Commission, PEPCO Maryland's MYP, that the commission denied our MYP. However, what the parties have not told you is that the commission approved an MYP for Baltimore Gas and Electric Company. That was the pilot utility. So they approved the MYP, a second MYP for the pilot utility, Baltimore Gas and Electric Company. And then, like I mentioned, convened a larger statewide lessons learned. Moving to AOBA, I want to talk a little bit about the reconciliation. The reconciliation is there, and this also gets to the arguments about cost containment. The reconciliation, the annual information filings give the parties and the commission the ability to look at our investments, what our actuals are, what are against our budgets, and ask questions. That's the insight that all the parties get to our plans. And the great thing about the reconciliation is that Customers only pay the actual costs of our investments. In that process, the annual informational filings, as well as the reconciliation, is consistent with what the Maryland Public Service Commission has done for 4 other MYPs. So it is a process, it's a structure that works. AOPA cited some articles from the Wall Street Journal. I'm not aware of those being in evidence, but I will just note that those statements in those articles are not been supported by testimony, and we've not been able to do data requests on that. AOPA also mentioned that there was a reduction of the ROE in the Maryland case from 9.55 to 9.5. That is indeed true. In this case, our ROE is much lower. It's 9.275. And as we've mentioned, that ROE is no longer supported given the financial and market forces that we see. I just may have your indulgence as I read through my notes here. There was talk about the BSA and whether or not it's still needed. The Atrium report, this is the commission's auditor, found that the BSA is still well designed to meet the goals of encouraging reductions in energy efficiency. One other point of discussion, AOPA had mentioned there have been no reductions in regulatory burdens. We disagree. The MYP, if it's for 3 years, we're only going to have a fully litigated rate case every 3 years. AOPA did mention that there are annual information filings, and that involves some level of work in between rate cases, but that level of work and resources put to AIF's annual information filings as well as reconciliation is not on the level of a fully litigated rate case. Turning to the District of Columbia, Counsel for DCG, District of Columbia Government, mentioned that we should incorporate cost-benefit analysis into our processes. Those types of analyses just simply aren't reasonable or work for investments for safety and reliability purposes. If they're done for safety, if they're done for reliability, taking a step back and doing a BCA just simply is not a reasonable request. DCG also mentioned the IDP, integrated distribution planning. As I mentioned in my outbound, our ACR annual consolidated report does have some planned investment component to it. So something like that does exist today for the parties to consult. And I will also note that, again, in Maryland, 4 MYPs have been approved without something similar. I'd like to talk about a stay out. I know that that was a point of questioning between DCG and Commissioner Beverly. What I will note is the implications of a stay out are pretty significant. In the testimony of company witness Lemming, we include the impact of the first stay out on the first year of this rate case, 2024, and that showed about a $20 million impact. So that contributed to the revenue deficiency that we see in this current case. So the impact to customers is strong.
Thank you for that. I want to first make a comment and then I will ask my question. Somewhere in your rebuttal, you stated that you file this information, it's incumbent upon the parties to avail themselves to the process. Why while that technically may be true, I want to remind Pepco that you have the burden, and it's not the party's burden to come back and double check your work. It's your burden to prove the prudence of your spending. So I just wanted to say that because I think it's a little unfair to put it all on the parties when it's your burden to carry.
And that was not my intent.
Okay.
We do meet our burden. We meet it when we file our MYP and we meet it when we file our annual informational filings. Then the parties have the opportunity to ask questions on our filing. So we feel we meet our burden, and my comments were not intended to shift that. We know we have the burden and we feel like we meet it.
Thank you. The other thing I will say is there was a lot of talk about, looking at non-wireless alternatives. And while I certainly understand that certainly some infrastructure investments are needed to harden the infrastructure, there is a space for non-wires alternatives. What are your thoughts on the non-wires alternative, Pim?
A non-wires alternative PIM, I think that should be discussed in the working group. We'd have to understand kind of what that PIM would look like before we could say that's something that we could adopt. I'd like to understand a little bit more about it, but I think there is a process and a proceeding available to talk about all the PIMs that we could possibly incorporate. So I would say that should be raised as a part of that.
The working group that has not concluded.
The working group, it has, I believe, filed a working group report, but that would be the place I would say that should be considered.
Okay.
And vetted.
Okay. Thank you, Ms. Curry. Before we adjourn, does anyone have anything they wish to raise or ask? Yes, Mr. Nair.
Council for OPC, I just had one question. I noticed that occasionally and I think Commissioner Trabe, you may have referred to this, where the attorney spoke as testimony, but it's an oral argument. Just wanted clarity on that, and not what we're saying is not considered testimony, correct?
No.
Yeah. Thank you.
Thank you. Okay. As a reminder, per order number 22015, conformed testimony and exhibits are due August 12th, 2024. In addition, if any admission of stipulated testimony, exhibits, data requests, and data responses are due August 21st, 2024. And finally, post-legislative style hearing briefs are due August 30th, 2024. There being nothing further, this concludes today's formal case number 1176 legislative style hearing. Thank you all for your attendance and participation. We are adjourned. Oh, Ms. Francis.
When Your Honor said post-legislative style brief are encouraged, is that, did I say that right?
No, I said they are due.
They are due.
Yes.
I'm not quite sure what that is. Is that like a brief that we normally do after an evidentiary hearing? What exactly does that have to do with today's hearing? Does that have to do with what has been pre-filed in the 1176 docket? I'm not quite sure what that brief is.
So typically with our hearings, we always ask for post-hearing brief, or at least give parties the opportunity to file post-hearing brief similar to 1169. I don't know what else to say other than that. Was it not your request to file post-hearing briefs?
We were requesting evidentiary hearings, and normally we do a post-hearing brief after evidentiary hearings. Right now, there isn't anything that has been, quote, as OPC said, placed into the record. So I'm not sure, do I brief all the issues in the case? Do I wait to hear from the commission if they're going to be evidentiary hearings? If they're going to be evidentiary hearings, we should probably wait till after hearings to put on the brief. It just didn't make, I don't know what to put in it.
Okay. My suggestion would be to, just as we ask for briefs in advance of the hearing, post-hearing briefs to follow that same format.
There has been no determination to have evidentiary hearings. My understanding is the
Oh, no,
parties has to do.
No, I recognize there's been no determination yet.
But I mean, the request to file post-hearing briefs was based on the fact that the commission, or at least my understanding of it, the commission had scheduled this legislative hearing. So you were doing your post-hearing brief, I thought, based on that. It wasn't based on any determination by the commission, as I understood it, that we were going to do evidentiary hearings. So as it stands now, I don't know anything about any evidentiary hearing. If the commission should decide to do that, it would be after today. We're not making a ruling on holding an evidentiary hearing today, so I don't know how we would answer your question. So if your question is, do you have to do a post-hearing brief on an evidentiary hearing that no one has decided to hold? I don't know how to answer that. Nobody said there's going to be an evidentiary hearing yet.
Oh, maybe I didn't phrase it right. If this commission decides to hold evidentiary hearings, then I would think we would want to file the post-hearing brief after the evidentiary hearings. At this moment, nothing has been placed into the record. There is no evidence. And I believe in its limited brief, OPC has taken the position they're not going to stipulate to testimony. It's incorrect. AOBA has taken also that position. So at this moment, I'm not quite sure where to go.
And I'm not sure how to answer that. So no one has decided that there would be an evidentiary hearing.
Correct?
If you don't want to do a post-hearing brief because there's no evidentiary hearing, I guess that's up to you.
Well,
Nobody's
obviously,
requiring
this-
it, but if you want to be able to say something in a post-legislative hearing brief, then you have an opportunity to do that. You don't have to have evidence to make a comment. You don't have to have evidence to do this. You presented a brief before the legislative style hearing based on the fact that there were no issues of fact. We still haven't determined that there are any issues of fact. So, I mean, it just is what it is. You can file something after this if you choose to do so as a post-legislative style hearing brief. But I can't tell you that you're filing a brief on an evidentiary hearing that no one has decided to hold.
correct.
Okay. I don't know what else to tell you. I can't give you that level of clarity.
Okay.
We're not.
I don't know.
We maybe get some guidance on when, if, and how such a determination will be made on whether there'll be an evidentiary hearing?
Someone determines that there are material issues of fact. No, we have not yet determined that, nor have I heard one.
So
I
that,
understand what Ms. Francis said with regard to what she thinks are issues that need to be explored, which doesn't necessarily translate, in my mind, automatically to a material issue of fact.
I understand. So, but the decision definitely, it sounds like, will be made after the commission has ruled on the pending motions. Is that
I'm sorry, which pending motion?
the summary judgment motions?
You can't, I don't know what, I think the commission has already ruled on that motion and denied it, unless I'm missing something. So there isn't any summary disposition of this case when you just went to a legislative, what's the summary part of it? So what would be the summary judgment aspect of this at this juncture? What's the summary element? So if the commission went straight to decision, I'm saying it would, if you went straight to decision after this legislative style hearing and after you got in your post-hearing brief, should you choose to file one, what is the summary nature of this proceeding? What are you getting summary judgment on? That's just judgment.
I assume that's a probably a better question for the parties that filed the motion for summary judgment.
I mean, typically when you file a motion for summary judgment, it's in lieu of going to some kind of hearing. That's the point of it. Okay, so after you have the hearing, I don't understand what the point is. You're just asking for judgment. You can ask for judgment on the same basis that if you think there should be PIMs, if you think there should be PIMs in the plan and there are no PIMs, then you can make a motion for summary judgment based on that, which the parties did. And you can argue that the plan shouldn't be approved without the PIMs, even if the motion for summary judgment is denied. You can still do that. That doesn't, the argument with regard to the PIMS doesn't disappear based on the presence or absence of a motion for summary judgment. So in answer to Ms. Francis's question, I still don't understand what else I can tell you other than there's been no decision that there are material issues of fact warranting an evidentiary hearing. So right now is legislative, as far as I know, legislative style hearing, and then the commission could proceed to a decision after they get the post-hearing briefs, which were factored into the schedule because you asked for it.
Oh, whatever.
I didn't say that you had to have post-hearing briefs. You asked to be able to file them.
If this commission decided to have evidentiary, if this commission decided to have evidentiary hearings, it's AOBA's opinion, it would make more sense to have a post-hearing brief after the evidentiary hearings. If this commission is not going to hold evidentiary hearings, I'm still a little confused about what to write because there's no, today was not evidence, so I'm not quite sure how to do a cite to quote the evidence because it hasn't been, nothing's been admitted into the record. So I'm just sort of having a
Don't have to
procedural
admit anything
nightmare
into
in
the
my
record
head.
to prove a point that's not in dispute. I don't want to, I don't have an answer for you to the level of detail that you're looking for
Mhm.
because I think it's working contrary. What you're asking is working contrary to the way this is currently proceeding. I can't tell you what would happen if you have an evidentiary hearing that no one has decided to hold.
Okay.
It may be that you have an opportunity to file a second post-hearing brief. I don't know. We're not there.
Okay, thank you.
So this concludes today's formal case number 1176 legislative style hearing. Thank you all for your attendance and participation. We are adjourned. Good afternoon.
Oh.